Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault.
If that isn't a great description for how my morning's going, I don't know what is. Hang on one second. We're going to start over. Oh, my goodness. Good morning. Good morning, everybody. Yeah, this is going to make the highlights reel for sure. Should we try this again? Everybody pretend that didn't happen. Here we go.
Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Trump saying, I didn't ask you to interrupt me.
Is that correct?
Prosecution. Not him, he Anglican boy. He's very much lucky.
Good morning, good morning. Welcome to the Court of Public Opinion. See, it almost was perfect that time. It was almost perfect. I have no idea who on the internet. All I know is that I am wearing green. Happy St. Patrick's Day, and this is what you get. I'm invisible today. Kimar won the internet right here. Okay, Kim, congratulations, your first day chat today. I know you're probably working overtime because you were fixing stuff for me already. That's why we're here. So thank you, Kim. Appreciate that. Let's see. Get focus. There we go. I'm here. Kim, congratulations. Thank you. We're going to add this to your permanent record. Just take care of the internet and we'll be happy. Floating head. It's not quite floating. It's like ghost RA is what we have today. Which, I don't know, this is just like, this is my whole weekend. This is how it went. I look to you how I feel. So yeah, it's, welcome. I could probably, if I found another cable somewhere, I could fix it. But we have a bunch of stuff to talk about and not a lot to watch, which is great, because, is the bathroom done, Cheryl? Too soon. No, but I have finished the floor. It's all in. It's glued, screwed, and ready to go. So the subfloor is all done. All of our plumbing is in and up through the proper holes in the floor, and the wall floor layout has been set and screwed down. So that's progress. That's a lot of progress. I'm a bit discombobulated. That is a big word for a Monday. It's a big word. All right. Who wants to tell him that chat's not on screen? Josh, you can tell me. Josh, by the way, thank you, my friend, for sending me a snack, which is maybe a third of the way gone already. Is this a serving size? Is 1 pound of pecans, farm fresh pecans from Arms Family Homestead, which, okay, I love pecans. The South is, here in North Carolina, pecans are the thing, right? We do pecans and we do them well. I will never be able to eat another pecan and not think that's stale because these taste amazing. Amazing. The freshness of this, oh my goodness. Arms Family does it right. Anyway, let's see, birthdays really quick. Yes, we'll do that. Let's do birthdays right away. How about that? Let's do birthdays right now before your son goes to school, Camilla. Let's see. Do we have birthdays ready to go?
Happy birthday.
There
you
it
look
is.
good.
Camilla, happy birthday to your son. Here we go. Hopefully your son's on this list. Oh, wow. Matt Bond's on the list. Awesome. Okay. Everyone stand up, take a deep breath, shoulders back, project your voice to the bathroom, blend your voice with your neighbors. Warm up with me, if you will. La, 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 la. There it is. All right. This is at least a 2-verser. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday to me, Gator, Sue, Gertie, Melanie, Rebecca, Craig, and Nicholas. Happy birthday to you. We got all the way to Nicholas, which means we still have just these people left. Second verse. Happy birthday to you. Happy birthday to you. Happy birthday, dear Stephanie Barnes, Corey, and Matt Bond Music Studio. Happy birthday to you. Gator Sue, Gertie, Melanie, Rebecca, Craig, Nicholas, Stephanie Barnes, Corey, and Matt Bond. Happy birthday. Did I get everybody? I think I got everybody. That's awesome. Happy birthday. I realize there are many wonderful days, but today's your special day. There are a million places you could have been, a million people you could have celebrated with, but you've chosen to be here with us. The privilege, the pleasure, the honor is ours. Hopefully, we can return that back to you and make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Bob Evans, and Andy's Grill. I recommend hitting all the establishments because, after all, it is your birthday and calories don't count today. Camilla, happy birthday to your son. That is awesome.
Happy birthday.
Thank you so much. All right. Whew. Tammy's are green pancakes at Tammy's house because it's that day, St. Patrick's Day. Happy birthday, Christina, as well. Thought I'd include some family members in there. So, 1 week away from mine. That's how I remember her birthday. So, did you go to your P.O. box this weekend? I did. Last case of emotion. Thank you. I have some things from you. Ooh, it's time for the drum solo. Everyone get ready. Big drum solo finish. Beautiful, beautiful, beautiful. Happy birthday, everyone who's celebrating. I hope you have a wonderful day. It's not my birthday, but I did get a present in the mail. I got my evidence delivery. My crime scene. I got the knife. Well, it's the knife sheath. So when we talk about Brian Koberger, we can understand what weapon we think was used and the knife sheath that was found and why the DNA would end up right here. Because it's hard to do that snap. It's a good place for DNA to end up. So that thing is just spooky. It is terrible. It's terrifying. I mean, look at this thing. It's a 7-inch blade. It is K-bar, U.S. Marine Corps, just like the one he had. 7-inch blade in there. It's a beast. But that little thing right there, that's all it took to implicate him. So good stuff. We'll put that somewhere safe. It's funny because this was out on my porch yesterday morning as I was headed to church, and I saw the package. I'm thinking, I hope it's still there when I get back, right? Because sometimes there are porch pirates. We've never had a problem with them here, but sometimes there are. And I'm thinking it would be funny because if somebody stole it, they would have stolen my fake crime scene evidence, and then it becomes real crime scene evidence. So it's like a little inception thing going on. All right. I also let's see. So I got some pickle stuff. I got some pickle stuff in the mail. Thank you very much, Rhonda. Appreciate that. Glass case of emotion. Thank you. Also got. I don't know who sent these. I got some chopsticks, some cheater chopsticks. They're connected. I think they're officially called conjoined chopsticks, which if you put two stacks together, you can eat twice as much at the same time. So you can eat just big fistfuls of food at the same time. Camilla says, it was me. Thank you, Camilla. It is cheating, but I'm excited. And I think this will help me. I'm not sure how well I can grab Cheetos with these. It will take a little bit of practice, but it will save me from having orange fingers all over my keyboards. So thank you. That was quite thoughtful of you. And of course, Josh sent me these pecans, which they're so good. And I gave some to Mrs. R.A. And it was funny because I was sitting here eating these. I'm looking out on the lawn, and there's like 50 squirrels out in my yard. I don't know why. There's like a squirrel infestation in my neighborhood. I'm like, I bet you want what I'm having. So, yeah, these are so good. They're delicious. Thank you very much, Josh. Appreciate that. All right. Good morning, Tony. Good morning, everyone else. Let's see. You never shared the big deal recording pickle. EDB has one too. The Big Deal recording pickle was stolen as soon as I got it from my kids. I do not know where it is. They've been hiding it places. I find it on the weekends when I'm going around the house, and I'll do something. I'll like yell to somebody, and then I hear my voice yelling back at me in a higher pitch, and it's the pickle. But I don't know where they have it. It's a dancing, recording, singing pickle. Follow the squirrels to RA's house. Yeah, that's what's happening. Tower Hill Girl, thank you, RA and chat, for keeping my company, keeping me company during a very hard time in my life. Tower Hill Girl, we're glad we can. Tower Hill Girl, 2 years, 24 months. You have the new color of courthouse by your name. That is just awesome. Thank you. If you're wondering why we're not in court right now, I could tell you, but it might be easier to show you. So let's see if we can do this.
Squirrel.
Let's see if we can show you. This is why we're not in court this morning. And I think it has to do with a cyber attack of some sort. But give us just a second. Let's see. I think I'm just going to turn that one off. Super source. Camera 2 is just going to be off. There we go. We're waiting for it to start. I might have backed up about 30 seconds too far. So maybe I should just jump to current time, and I'll tell you what happened. They sort of had a cyber attack issue, and the court can't proceed the way they wanted to. And so they sent the jury home. And now they're coming back for oral arguments only today, and we're going to jump in and listen to those just briefly, and it's probably going to be pretty quick. So let's give this a listen. Now, jury's at home. So just the lawyers here, no jury. We'll argue a couple different things. Probably, if they're arguing, it's most likely that the state is going to rest next, and so they're arguing the judgment of acquittal. Lots of cyber attacks. Yeah. It's really noisy. That's all on their end. So my gig this weekend is they're getting prepped. In my gig this weekend, I found out that we can't just use YouTube closed captioning by delaying the broadcast and having the auto closed captioning work. We actually have a professional closed captioner coming in who is going to be providing the feed that I'll be overlaying on top of the video, in addition to the Spanish language feed, and 2 pan-tilt zoom control cameras remotely operated. And then we've got to set up, I don't know, like 4 different display monitors in different wings of the building for different rooms and different languages. It's gonna be crazy. Josh, I've got that. We're gonna watch that as soon as this is over. Can I explain what a cyber attack is? Melanie, they can be a couple different things, but generally you can have a computer reach out, say like when you try to Google something, you send Google a request and it responds quickly. Imagine if you had 100,000 computers who all at the same time wanted to send Google a request. You know what it would do? It would handle it just fine. But imagine you had the control of, say, I don't know, 1 million computers, and you use those computers to send requests every 1/9,000th of a second to Google. And you say, who has control of 1 million computers? That's what a virus is. Virus, malware, you get a virus on your computer, and you're like, why is it running so slowly? It's because somebody else is using your computer to do their dirty work on the internet. Oh, I've got a spam call. So, hang on, let's see if we can do this. Hello?
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 Hey, good morning. Kiara here. I'm reaching out to share exciting news about new Medicare benefits for 2025.
I need a human on the line in 3
medication,
seconds or I'm hanging up.
And up to $250 cash back. Are you currently in?
So close. You almost made it. So cyber attack is generally it's a denial of service attack where they use the service to flood the server with requests that are illegitimate, and so the server is so overloaded with requests it can't handle anyone else's request. But software virus, yes. And software viruses are super, super easy to catch on your computer. It might be some email from somebody who's like, here are the pictures from this weekend, and you click on the file and you now have a virus. It could be something that looks like it comes from your bank saying, hey, please fill out this form or we're closing your account. And now you have a virus and somebody else has all your money. It could be somebody Googling on the internet and saying, hey, I found a website where you can download all the movies you want for free, and you can, and now you have a virus. There's a million ways to get your computer infected. But I got a text message today from companies like, hey, thanks for requesting to withdraw your money from this. It's a cryptocurrency platform. If you didn't make this request, please call us immediately, or please reach out to us immediately. And it gives a link. And the link is fraudulent. It's literally, they're phishing to try to get people who say, oh, I didn't request, I'm not cashing out my money. Hey, stop that. And they get your information when you call them and say, hey, don't give out my money. And then they take your money. So everything's a scam nowadays. Let's see. We're waiting. I think I'm a tiny bit behind. Let's see how far back we have to go to catch up to the... Here we go. There we go. Waiting for the judge. We're going to have some arguments here.
Good morning, everybody. Thank you. You may be seated. All right, so for the record, we are back here on this matter of the state of New Hampshire versus Jason Levesque. This is 2024 CR 273. As I discussed earlier, because we're not having testimony at this point, I thought it was a good opportunity for us to address the various motions that were filed by the defense over the weekend. Oh, before we do that, though, counsel, I should let you know I have copies of my proposed jury instructions, which I did over the weekend, for you all. You're welcome. Do you have any? I have 3 sets there. So we should still have plenty of time that you'll have a chance to review those and get back to me. I have included, just so you know, I included the long form self-defense standard instruction. You know, there's a short form and sort of a long form. I've included the long form self-defense instruction, which was my plan all along. So that basically matches, I think, what the defense was asking for in their proposed jury instruction. To the extent, Attorney Sisti, that there's anything, I think I've captured everything you asked for in your proposed jury instruction. To the extent that there's something different, obviously you're free to raise that. I did also include language about not only self-defense but defense of other, because I do think you have raised some enough facts that should go to the jury as well. So I've crafted it, but if the state wants to object to that, I will hear from you. And if you need time to think about those things. The other thing I did that's unusual in my jury instructions is, you know, there's a standard jury instruction for prior inconsistent statements, and that prior inconsistent statements don't come in for the truth of the matter asserted, but they're only used to assess the credibility of the witness. I've chosen at this point, and I'll hear from you at some point about this, to eliminate that, because there really have not been any prior inconsistent statements that I'm aware of that have been used to impeach anybody in this case. And the only prior statements that have come in were the prior statements that the state put in as substantive evidence under the rule of evidence for prior for prior recollections recorded. So I think it would be confusing to the jury if I gave them that standard instruction, which says basically you're not to consider out-of-court statements for the truth of the matter, when in fact there are some out-of-court statements that they can consider for the truth of the matter. So I think it's actually better just to not discuss prior statements at all and leave it open. But I just want to highlight that to both of your attention, because that is one change from the standard instructions that I did in these. Otherwise, they basically follow the standard instructions, but feel free to let me know if you have any concerns. All right. So that leaves 3 other motions we're going to take up at this point, and I think they make sense logically to start with the motion for a mistrial. So I've reviewed the defense's motion for mistrial. I fully understand that the state has not had an opportunity to file a written response, given your computer issues. If at some point you feel the need to file a written response, let me know, but I think at this point we'll go by oral arguments. Attorney Sisti, it is your motion. I'll hear from you first.
Thank you, Your Honor. And, there's a little bit of background here. This issue, or these issues, really didn't rise until Friday afternoon. And around 2:30 in the afternoon, it was announced at the bench on the record that Kyle Violet would not be testifying in this matter. And I can assert, and I'm sure the state will agree, that that is a development that was not anticipated. It certainly was not in play on the 3rd of this month when we were selecting a jury. And it wasn't in play when the court had contemplated preliminary instructions with the jury. I can say that voir dire on the defendant's part was framed around the assumption that the alleged victim in this matter would be testifying. And in fact, that assumption would have been buttressed certainly by the voir dire of the state with the potential panel as well. I think both the state and the defense were raising issues with the panel in expectation of Mr. Violet taking the stand.
Counsel, maybe you can fill that out for me a little bit, because I read that in your motion and I was a little, I wouldn't say puzzled, that's probably too strong a word, but I was curious as to how you would have voir dired the jury differently if you had known from the outset that Mr. Violet might not testify. What sorts of questions would you have asked, and what sort of bias or would you have tried to ferret out from the members of the jury that you don't think you were able to?
Yeah, we would have actually gotten into what I have proposed as a missing witness instruction with the court. And we would have delved into their belief on that particular issue. Some people would take that and embrace it. Some people may not have been able to follow that instruction. We don't know at this point in time. But it would have been something that would have had to have been raised, because maybe we should get into this a little bit deeper.
The audio is terrible. Let me pause it and explain what's happening here.
With a self-defense instruction.
Let me pause it just for a second. This audio is terrible. They're arguing a mistrial motion, which is made by the defense, and the defense is saying we are arguing for a mistrial because the victim did not testify. And the judge is like, hang on, explain that one to me. That, the victim doesn't need to testify, but everything going up to that point, the victim was going to testify, and they'd been noticed that the victim would be testifying, and so the defense is now saying we would have done things differently had we known. This is a late change. We would have talked to the jury during voir dire and said, how do you feel about a case where the victim doesn't testify, where there's a missing witness, a key witness that's alive and available but is not testifying, and we would have asked different questions. And thus, because we're not allowed to do that, we can't go back and do that now. We believe we have a mistrial. I don't think he's going to get this. This is not a strong argument to say it's a mistrial because the victim didn't testify. There's just less evidence against his client. I would say that's arguably better unless, of course, the victim is terrible on the stand and contradicts himself and things like that. But let's go back and
The voir dire is quite different than me trying to delve into them, trying to judge the credibility of witnesses. They would not have to judge the credibility of Kyle Violet. In fact, they would have a presumption, or they would have the inference that his testimony, in fact, if he testified, would have been unfavorable to the prosecution.
But that only works if the court were inclined to grant the missing witness instruction in this case. And that's so I see how these issues are all sort of intertwined.
Yes. No, I understand that. I mean, although there's a difference between the missing witness instruction and the missing witness argument. The argument can be made without the judge's, without the court's instruction. There can be argument with regard to, why isn't he here? He's the alleged victim. There's no good excuse for him not to be here. That can be covered without the instruction.
Courts have allowed that. Courts have certainly allowed that. With the caveat that you can't ask the jury to speculate about things that aren't in evidence.
Right.
But I can carry on.
But the problem is, we weren't able to get into it. And I don't know what the rules of the game were during the course of voir dire. And quite frankly, neither did the state.
Right.
I mean, neither did the judge. I mean, we were all sitting here.
Right, but to the extent that that's an issue, you can raise it in your closing, right? I mean, how?
No. I can't re-qualify a jury on closing. All right. I can't re-strike a potential juror on closing. I can't move for a cause on a juror on closing. I mean, that's what voir dire is about. Mm-hmm. That's what jury selection is about. And that's why we're given and afforded the opportunity to question during the course of voir dire, and that is to vet out the issues that are expected at trial. This is a totally unexpected development. Totally unexpected development. And, in fact, on the third, I looked at the note, and part of my question had to do with the intensity of the contact, with in fact, the initial aggressor aspects, the fact that they have to look at the credibility of the testimony of everybody, and then that was reasserted on the 12th, on the opening, where the prosecution asserted he was the victim on the opening. Right? Asserted certain words that he would be saying, their version of what the words would have been on opening, which, by the way, he's never going to be able to testify to.
Well, my memory is, and I'll let the state talk about this, my memory was that in their opening, they almost, and I was struck by this, the state never used the sort of standard language you hear in openings, like, you're going to hear from Mr. Violet and Mr. Violet. At least my memory is, I don't recall the state making statements like, you're going to hear from Mr. Violet and Mr. Violet is going to tell you X, Y, Z, which, frankly, the court took as a hint is probably too strong a word, but a suggestion that the state, in opening, wasn't certain that Mr. Violet was going to be available to testify as a witness in this case, and I'm sure that you must have been struck by that too, the fact that the state never once in their opening said that sort of language that prosecutors routinely say. But I could be wrong about that. I'm just going by my memory of the openings.
Well, my note indicated that some of it was, if you leave fucking snow in front of my fucking house, I'll kill you.
Right, but that came in, but that's coming in from the defendant. I thought that they were saying that that's what you were going to hear that the defendant said that he said.
I am stating to you that would have been a statement from Violet.
Okay. He testified, right?
And there would have been more, but and frankly, that's where we were going with this. Is that it's not just there, that there's intensity, that there are core issues in the case, that credibility is one of them. In fact, there was an objection raised by the state on the credibility issue when I said that Violet wasn't straight with the prosecution, he was straight with the police. And and that was argued at the bench, and in fact, that was a withdrawn part of the opening. By the way, I anticipated that if he did take the stand, all right, that he minimized this particular event. He would have had an interview, I think it was on May 29th of 2024 with the police. In fact, one of them would have been Detective Danny looking on in the CAC room, where Violet basically said, "Oh, I was just going out there. I didn't want a confrontation." I mean, I'll make that offer proof to you right now. That those are basically the words that he was urging the state or the prosecution to embrace, which are completely false. All right? And these are the areas that we were setting up and getting ready to deal with him on.
Mm-hmm.
Okay. Now, these aren't small things. I mean, he's a big player here.
Oh, I agree.
Right. I mean, he's the alleged victim in a case. There has been, as the court just noted about 10 minutes ago, there's been evidence adduced at this trial where a self-defense deadly force instruction is going to be read to the jury, not only protection of himself, protection of his daughter in this case. So that end of it's in. The question is, if you join that for purposes of the motion to dismiss, and I have to jump back and forth, I'm sorry.
Understood.
If you join that with a missing witness instruction, the state's case is gone. It can't sustain itself if the alleged victim's testimony would be presumed or inferred to be unfavorable to the state's theory of prosecution. And there's a self-defense instruction. If you put the two of them together, it doesn't even make it across the hurdle of a motion to dismiss at the end of the state's case. It certainly doesn't make it past the hurdle at the end of all the evidence. The case can't go to the jury at that point. I mean, what's the issue? What is the issue at that point?
Well, I mean, setting aside the missing witness instruction, if it was the mere fact that the witness is not available and that you've raised self-defense surely can't mean that the state can't meet its burden. Otherwise, you could never pursue a homicide case when self-defense is raised. Clearly, the state can meet its burden overcoming self-defense, even though the victim isn't available to testify.
No, I disagree vehemently with that statement. In fact, that's the difference between a missing witness and a deceased individual, because that individual is deceased. With a missing witness, that means that the witness in this instruction, there is a comment by the court where that individual, if that individual were to testify, all right, his testimony would be unfavorable. With a deceased individual, of course, you can't get a missing witness.
Right, so again, that's only if I give you the missing witness instruction.
And I'm arguing off the basis of the missing witness instruction.
Okay, maybe I'll just start with that. I mean, I was trying not to do all three motions at once, but we may inadvertently end up doing all three motions at once. If you want us to try to disentangle them or be heard more, I'm happy to do this however you want. But the missing witness instruction is tricky because, I mean, I think the case law is pretty clear. If you look at Ramos, I'm looking at State v. Ramos, 121 New Hampshire 863. It's a 1981 case where the Supreme Court held that the court should not give a missing witness instruction where the witness is equally unavailable to both sides. And my understanding from the offer of proof that the state made, and maybe we need to get into this at some point as to what the level of proof needs to be on this question and whether there needs to be more than offers of proof or some sort of testimony. But my understanding from the state's offer of proof previously was that the witness is unavailable to testify because he is simply not in an emotional state to testify. And it's akin to a form of illness, right? He's unavailable because he cannot testify, despite their efforts to get him to testify. And when this court asked whether the defense intended to call this witness, who was under subpoena, you informed the court at that point that you did not intend to call him as a witness yourself because of of what the state had alleged, which was that he's not well enough to testify.
Let me clarify myself. One, I'm very familiar with Ramos's case.
Okay.
That was one of our initial cases in Manchester when we started. And I'm extremely familiar with Ramos.
Okay.
This is a completely different situation. Completely different situation.
Okay.
This is a witness that is aligned and would be more favorably tending to deal with the prosecution. In other words, this is a person who, in fact, the state's theory of prosecution is based on. One. Two, he is certainly more available and in contact with the prosecution than we ever could be. All right? And that's part of the test, by the way. All right? Part of the test is whether or not there's an affiliation with one party over the other. It's pretty clear there is. In fact, the First Circuit instruction is if it's peculiarly within the power of the government to produce a witness who could give material testimony, or if the witness would be favorably disposed to the government, of course it's going to be favorably disposed to the government. Failure to call that witness may justify an inference that his testimony would be unfavorable to the government. I mean, this is a simple test in this case.
That's the First Circuit's test, yes.
I mean, we're in the First Circuit, and it's the due process area, and that's an issue that's alive and running right now. But I also have to say, I don't agree with offers of proof on his unavailability, so I think we should take that off the table right now. There's been no proof, as far as I'm concerned, that he's unavailable, other than he's not being called. And that's what the facts of the situation are. I'm not going to call him. He's more predisposed for the state. At this juncture, he is the poster boy for their prosecution. He is it. All right. Now, I mean, the true test is, well, if you look at any of the other states, in fact, just the Commonwealth of Massachusetts. It's the same test as what I just read from the First Circuit. If he's more affiliated with one party over the other, then boom, there you go. And by the way, again, you have to be really careful about why don't I call him? Well, we don't have a burden of proof, and that's also announced in all the cases.
Understood. I know that.
So, I mean, that argument means nothing. And the fact, by the way, that he's under subpoena, that means nothing. I mean, those all wash out in case law if you look through it. The real question is, who's he affiliated with? Who does he identify with? Okay? Who has more control over him? I would suggest the prosecution does, the victim advocate does, certainly not sister law officers, and certainly not Mr. Levesque.
Understood.
There's actual hatred there.
But do you have a single case that you cited? I haven't seen one. I haven't found one myself where the court has given a missing witness instruction when a victim was, for example, sick, unavailable because they were ill. Do you have a single case where a court has given a missing witness instruction in circumstances like this, where it's not just that he's not here, but the representation being made by the state is that he's emotionally, psychologically unable to testify?
Well, maybe we should have known that before we started the trial, Judge. I didn't know it was such an acute situation, and I don't have one psychiatric report in front of me to sustain that particular conclusion. And I don't think the court can come to that conclusion without competent medical, psychiatric evidence before it, a full hearing on that particular issue, and not an offer of proof. And also, if he was suffering from that at the beginning of this trial, don't you think we should have known about that? Don't you think that that's something that the defense should have known, and that we should have been able to ask the court in a Gagney-type motion to review just what is going on with him, so that we can confidently cross-examine him at the time of trial, when he is called to the stand, anticipated to be called to the stand? I mean, those are the other issues. If in fact, they were of knowledge that he was having a problem before 2:30 on Friday, we should have been notified of that. Okay. I would have had a motion in there asking for that.
Okay.
Before he was cross-examined.
So I know I've taken you off track, and I apologize for we've jumped around on issues, and I've sort of peppered you with questions. But so if you want to go back, I mean, we started with the motion for mistrial,
Right.
Which I think I understand your position, which is that if you had known the witness would not be available, you would have done voir dire differently, you would have opened differently, you would have prepared jurors for the idea of the missing witness and the missing witness instruction, probably would have been talked about earlier, etc. Is there anything you want to add to that?
Yeah, on that as well, and if he was suffering from some condition, all right, that we should have been notified of that as well.
Okay. Fair.
So none of that's there.
The motion to dismiss, I mean, it's a little premature. I understand where you're going. You're arguing that between self-defense, if you combine the self-defense instruction with the missing witness aspect and the inference that the jury is allowed to draw for the missing witness, and your position is the state can't meet its burden in this case.
Right. And I want to be clear because I don't want any misperceptions. A missing witness instruction can't apply to your normal homicide case.
No, right. I understand.
And I don't want to get off base here because I think we should all understand that would be an impossibility.
No, of course. And I prefaced my question by saying, setting aside the missing witness problem,
right.
The mere fact that you don't, the missing witness instruction, the mere fact that you don't have a victim who can explain what happened doesn't mean the state can't meet its burden of overcoming self-defense.
I would say
on its face.
In extraordinary circumstances, that may be true.
Well, in every homicide case where self-defense is raised.
Oh, yeah.
Right. I mean, in every homicide case where self-defense is raised, the state has to meet its burden of disproving self-defense without the person who can give that side of what happened. And that happens all the time.
That's a given.
But your argument is when you add the missing witness instruction and the inference which the jury is permitted to draw, but not required to draw, the inference they're permitted to draw, then you think it prevents them from getting over the hurdle.
Yeah, that's a problem, and it's also a subject of. I'm going back to the beginning again.
Mm-hmm.
That's something that would have been addressed on board here, and that's something that would have been addressed on open. Right? That inference, how it impacts, and what we would strive them to do if we get to that point at the end of the case.
Okay.
So I mean, we're left without that ammunition. We're left without that, and I mean, I don't know what the timing's about.
I'm sorry?
I've worked with Chuck forever, all right? In federal court, county court, public defender. I don't think he's hiding the ball. I mean, I'm sure Sarah's not either. But I mean, that's something that came up and kind of snuck up and bit us all on Friday afternoon. And it's difficult for me now to replay all the things I would have done knowing that, but there would have been a lot. I mean, the Gagney motion itself would have been filed immediately if we knew there was a problem. Okay? I mean, I would have been rightfully asking for his mental health records, or at least to have them submitted to you so that we could know whether or not there was relevant material in there to probably deal with two issues. One, his credibility, and two, what we're arguing about right now.
I may have misspoken. I didn't mean to imply that the court has reason to think that the complaining witness in this case is undergoing any mental health or psychiatric treatment. I have no way of knowing. I just was given the offer of proof from the state's counsel that he was emotionally not able to participate in the trial. But I'll hear from the state. I'm sure they'll clarify all that.
No, actually, I'd like the opportunity for the state to, address any of these things. I mean,
Sure.
It came up quick, and they're not beautifully vetted for you. I have to tell you that. I mean, it's pretty quick research.
I'm not criticizing your research abilities. I know the motions had to be filed quickly.
So yeah, I mean, if the state wants to throw something in there, it may, quite frankly, be very, very helpful in resolving this.
All right. All right. I think we've discussed all the legal issues. I mean, obviously, the self-defense I think is not an issue at this point because we've already moved on that. State, I'll hear from you on the motions. As you just heard, they're sort of all intertwined.
Yeah.
The State wants to try to tease them out, feel free. But
Yeah, I understand. Look, let me just start with kind of the progression of our assessment of Mr. Violet and how we got to this moment with respect to his condition. And this clearly, isn't unusual. I mean, think in terms of a domestic violence case involving serious trauma to a victim. It's very frequently a fluid situation from beginning, middle, to the point of literally testifying about where a victim comes down in terms of their capacity to go back and revisit the trauma that's at issue and to talk about it in detail. We have had and frequently have cases of domestic violence involving serious trauma where we find ourselves in similar positions, and we make decisions about whether to go forward with, quote, victimless prosecution. And victimless prosecution, I have never seen it serving as a legal basis to invite inferences with the missing witness instruction. So more specifically to this case, I'll say that or disclose that, right from the outset, after Mr. Violet was released from the hospital, police approached the issue of when and how to talk to Mr. Violet, who had been in, for periods of time, a coma. We heard when investigators went up there, he was in, quote, no condition to make a statement. And that issue was revisited, and I believe the police reports and discovery indicate a few attempts to go and talk to him where he simply turned the police away. And that ultimately investigators turned to the CAC process. That process was explained by Detective Danny, who indicated, when we have certain victims with children, for instance, go to the Children's Advocacy Center in order to make statements in a certain environment with certain trained interviewers with techniques that are designed to address, for instance, the sensibility of children who have endured violence. But that is not exclusive to children. We frequently use it for domestic violence. And we used it here, given Mr. Violet's experience. It generated a CAC. Then over time, and obviously we don't press witnesses during the pendency of, say, the 8-9 months of a case and constantly revisit their testimony and their experience over that time. In normal fashion, we approached Mr. Violet, I think within a reasonable period of time prior to trial, and it was clear to us that he was in a traumatized state, but not one where I was going to abandon hope that he would be able to testify. That it has been my experience over many years dealing with witnesses with trauma that it's fluid and there's a step-by-step approach. And at one point, he was able to disclose to us that his intention to testify. I'll say that during the course of trial, that the trial itself has been traumatic. That the turning point was, as I understand it, Mr. Violet actually watched on the live stream the body camera of Sergeant Hurley. I think you recall was in fact a very real-time experience of him dying in the street, and he watched it. It was Hurley packing his wounds. It was Hurley putting fingers into bullet holes. It was watching blood drain from his throat. And maybe that was ill-advised. We didn't know that he was doing that. He had every right to do it.
Understood. And I went back and thought more about it after. I know I gave you a look when we talked about that. I mentioned I was not thinking the victim's bill of rights at that point in time. It doesn't have to be supposed to.
And so, well, he wasn't sequestered. My understanding is he watched it, literally on his phone down the hall. But my understanding is he went from there to a very acute state of PTSD. My offer of proof, and again, I haven't sent out an investigator, but that he sealed his windows, closed his curtains, and was in a non-communicative state, a state of high distress. We had revisited that with family members.
I'm sorry, Counsel.
The source of our information was Angela. By the way, the state of the record is, I asked without objection, what's his current medical state? It is still fluid. He went to a orthopedist last week that surgical requirements are continuing to unfold. But I also ended it with, how's his mental state? Because, he goes into depressions and he has extreme PTSD. And I did not go into the details of how that manifested or how that manifested that week. But I just offer this as maybe not a substitute for gagging, but just as an explanation for the sequence of events that got us here to Friday. I had some contacts with him in our conference room, and it was very clear to me. I reached what is a subjective determination, not with the benefit of his physicians or treatment providers, but that he was not in a state to present testimony in this case. I concluded it in terms of what is akin to a medical issue that is trauma-based, not recalcitrance, not being reactive to the interests of the case itself, but simply to his current mental state. And that's what I got. And I've told you that we have been making efforts to get a summary letter from his physician, his provider, concerning his heart condition, concerns about this protracted trauma and revisiting the trauma in this type of detail in an adversarial process of what that translates to in terms of risk. I don't have that yet. That is a work in progress, but I'll concede to the defense. No, we don't have the conventional gagging. We have a witness, as I've described, that's gone through by the way, not surprising given what we've seen and know of his experience, a escalating traumatic response to evidence that he's heard, to my efforts to have him revisit this for purposes of testimony, and this is where we're at. I am not going to put this human being on the stand on my needs, and I'll accept the consequences. But let's get to the consequences. I don't think there are any, as a practical matter, because this does not fit as a matter of law. First, the missing witness instruction, and particularly in the context of mistrial. The missing witness instruction, as the court noted, Ramos did indicate that it had to do with a kind of a concurrency, a balance of access to a given witness. I want to point out that when the defense filed a witness list, the last witness was every witness on the state's witness list. And that's expressed, and I get that as kind of this insurance policy. But bottom line is, Mr. Violet was not released from subpoena. In theory, the defense could call the witness, and I get why they would not, having more to do with, and no offense, or I'm not trying to be provocative here, but bad optics for a case where the defendant inflicted the physical and emotional injury, then put him up as Exhibit A of somebody who can't, address the facts here. I get the tactics of it, but I think what we really need to do is then talk beyond. Both sides could call him. at their peril, and that applies. And so does that automatically take it out? I'm aware that the First Circuit takes a slightly different view federally of this generally predisposed towards one side or another, but it doesn't end there. That's not the end of the analysis. The analysis from courts generally goes on to other issues like, is there a material aspect to this witness's testimony? Answer, sure. Yes. But the most significant issue here is twofold. One, what's the reason the defendant isn't appearing? And I think I've just addressed that. It's trauma-based. I think your comment on homicide and, for example, victimless prosecution of domestic violence is in fact on point for the reason prong of the missing witness instruction. There is a reason here. It's not just fickle. It's not unknown. It's not just a decision to be obstructive from the witness. We don't have that in that case. And, you know, it's not a witness standing up saying, you know what, I'm not going to give the defense the benefit of tactically advancing interests against me in a civil or criminal case. Don't have that here. The fact is that it could apply to homicides and domestic violence victims, but it doesn't based on the reason analysis. And, you know, just to dismiss homicides as just, oh, that doesn't make any sense because they're dead and unavailable. But what about all the body of evidence that, you know, preceded the death? We can't get that in many instances. You know, a consent case to high-risk behavior, the defense raises a consent defense to the victim was deceased during this consensual encounter, and therefore it's a negligence case and not a first-degree murder. Defense doesn't get an instruction that says the decedent isn't here, therefore you can infer that she consented to this high-risk behavior. It doesn't work that way because that is not the spirit or intent of the missing witness instruction. So I do think there is a general guide to the notion of unavailability in that sense, the availability of that evidence, and that's the reason base. We're not there. He's not dead. But he's traumatized as the basis. But most important, let me just address what the core of our argument is. Almost all courts that I'm aware of, and by the way, I think I've conceded that my research has been somewhat compromised, but cumulative evidence. Here's the issue in this case. It's so narrow in terms of what the defense has ever claimed and the state's concessions about what's missing from this case. The defendant's actions, not missing. We don't need the defendant to say, here's what I did, and here's what the defendant did. It's on video from 4 different perspectives. We've lived that all last week. And so the actus reus element of this particular offense is fully established. He could get on the stand and say, you know, I looked out the window, I saw it snowing, and I saw the defendant plow. That's all there. We've heard that from 2 other witnesses and 4 videos. Then I went outside and I confronted my neighbor about the snow. We've got that. The issue is the use of force. We've got that. The issue that the defense is saying that we no longer have is the ability not to establish verbal confrontation. The state virtually conceded it in opening statements. You know, that quote that Attorney Sisti read from me in opening was from the defendant's claim. If you move that snow over to my driveway, I'll kill you and your family. Isn't from Kyle Violet, it's from the defendant. He repeated it 4 times during his interview. Without change, without reference to his daughter, always a conditional threat. That was what I said in opening. And, you know, you're right. It wasn't because I knew he wasn't going to testify. It's because I started to have concerns. And I didn't want to anytime I can avoid a credibility contest over certain issues and focus on, if this happened, and we'll accept that it did, we still win this case. That was that opening. I accept. I accept tactical criticism from all my work, but I did, and I consciously did, a defendant point of view of this self-defense case to say that even from his perspective, the state wins, because this was there was no imminent use of lethal force, no reasonable force, and that's the issue here. And so the defendant, and by the way, I'll make this offer proof. The next witness coming on, Garston, we anticipate putting on the defendant's claim of what these threats were, and without impeachment. What he claimed happened next is in sharp contrast to the video, and we'll point out, everybody's been pointing out that, hey, you can't hear what was being said there. We've adopted from the outset that the defendant's claims about what Mr. Violet said we'll live with. As an aside, do we have countering evidence of that? Did Mr. Violet say something contrary? Yeah, he said a reduced, intense version of that. But so what is left for the defense is simply to say, I want to put him up to impeach him, to say, oh, you said that you went out there to not have a deadly confrontation, that you said something to the effect of, if you continue to if I could be direct, fuck with my family, I'll fuck with your family, something along those lines, a slightly diminished version. Our approach to this has been, so what? And that's the heart, then, of this missing witness instruction, is that due to its cumulative nature of the evidence, the one side should not be able to invite the jury to speculate that it was something else. What exactly? That he did say, if you put snow in front of my driveway, I'm going to kill you and your family. I mean, we're already there. So that makes it about as cumulative as you can get.
Can you respond to the defense's argument that if we had known in advance that this was going to be a victimless prosecution, so to speak, that we would have done different in our opening, we would have approached voir dire differently, that it's unfair to the defense because they didn't know this is going to be a victimless prosecution situation? What's the state's position on that? Two issues.
Then let's get to, I think, which would be the mistrial analysis. We would have done things differently. The mistrial motion, notably, at least I didn't see it, invoke the actual standard, which is manifest necessity. We're dealing with a standard of prejudice, of unfair prejudice, that is such a degree that the defendant's very basic rights to a fair trial have been compromised. And what they initially raised in the motion is, we would have made tactical decisions differently. Tactics don't rise to quite that level. Tactics change. I think the court is well aware, we're all well aware doing this work, that it is about as organic and fluid a notion of preparation. Everybody's got a plan until you get punched in the face, and that's what happens here in a figurative sense. And this wasn't a punch in the face in that it's not planned, but witnesses frequently get up on a witness stand and say something different than you anticipate, and your tactics change. That's kind of the situation we're in. Although, I'll concede that this is of a degrees matter, and still, this isn't one fact deviation. This is a central witness. But the differences in terms of what Mr. Violet would testify to, again, I've already gone over the cumulative nature of it. Walking out of his garage, putting on a shirt, approaching Mr. Violet, getting face to face, walking away, walking back, seeing a firearm be produced, turning away, getting shot, crawling home, being in really a state of dying, are the elements of this offense. Bodily injury, the intent to kill are established by the medical evidence, and the act of this offense is literally documented by video. So what degree of change of tactics are we talking about has to be measured and assessed in light of the actual evidence in this case. I was struck by the notion of, in voir dire, I think the quote was something like, we would have been telling the jury what to do about that, but that's not voir dire. We don't get up and tell jurors what to do during a case in voir dire. I think probably both sides pushed up against that line a little, as is the practice, particularly in this county. But that doesn't change, what you're able to do in voir dire. You're not supposed to be able to bring in case-specific issues of that kind of degree and ask the jury to, hey, get prepared to respond. That's opening statements at most, and even opening statements shouldn't be making argument. Opening statements can raise issues. And obviously, if they had known that he wasn't going to testify, we both would have changed our tactics to address that, what is now something of an elephant in the room, but one that's really, frankly, overstated, as I said, given the margins of evidentiary and factual disagreement between what Mr. Violet would say happened and what the defendant has said happened. And that's
I think he's running out of steam here.
Eliminates the missing witness instruction, and two, I think forecloses a mistrial analysis in this particular case. To summarize, this witness is not peculiarly available to one side. Both sides could call him. There is a rational reason other than obstructing the opposing side from obtaining evidence. And this is fundamentally cumulative evidence to the extent that it deviates from cumulative in the actual statement that is made, favors the defendant at the outset of this.
I'm going to pause this for just 1 second.
We're put in a position of conceding that point, which we more or less did at the outset of the case.
We're going to pause for just a second. This little bit, we have the defense who's saying, we want a mistrial. We're all mad and our panties are in a bunch because the victim isn't testifying. And had we known he would not testify, we would have done everything different. They're trying to take something that was actually good for them, because the victim testifying will probably be bad for them, and turn it into a win. Or they're trying to make it look like a loss so that they can get a win. If they really want to push this issue, here's what you do. You put your client on the stand and he testifies that the entire time this exchange was going on, the defendant was reaching in his pocket as if he was going to pull out a gun. And I felt threatened the entire time, and his hand was still going to his pocket until I finished shooting the 5th round. Now you have a situation where it's like, I was afraid he was going to shoot me or my daughter. Okay, I'm not sure I'm just presenting this for argument. I have no idea if these are facts or anything. It doesn't exist because he didn't make these statements to the police. But then you present the case and saying, in those moments that only 2 of us heard, this is what happened, and the state has nothing to counter that. Then they either have to call him, and he has to either deal with the very traumatic issue of taking a stand and testifying about these things, or the state has to concede that. But defense can still call him, and I don't think they will. They don't want to call him because, first of all, it would be on direct. You wouldn't be able to lead. You would have a semi-hostile witness, but probably not enough so that you would have to be able to lead the witness, and you wouldn't be able to. It would be a loss for you. Anything that comes out is probably bad. So let's continue.
What's your response to that?
Yeah, I appreciated that argument, and I think that we're starting to focus in on some very important points. Again, we don't accept the offer of proof with regard to Kyle Violet presently being so traumatized that he is the equivalent of a dead person and is unavailable. Okay, so I just want to make sure that we're clear on that, because there hasn't been any competent evidence adduced at any hearing to support that factual allegation. I'm extremely clear on that. And two, it also opens up a can of worms, because if the state had been dealing with Mr. Violet over time, and they came to a conclusion that he had some significant or substantial psychiatric condition, that's something we're supposed to know. something we're supposed to know so that I can bring that to the attention of the court. And I can say I reasonably believe, under Gagnon, that there's an individual that may be suffering from a disability or mental defect, and I want the court to take the material, if it exists, and review it so that I can have relevant portions of that particular report or reports, so that the court can make a determination as to whether or not it's exculpatory, just like Gagnon, whether or not it's material, whether it's something that the defense should have. None of that was brought to my attention ever over the past year. None of it. We didn't know that he was in some kind of counseling. We didn't know he was. I don't know.
Well, I didn't hear the state say that, and I do want to just reiterate, to the extent in my questioning to you, I think I made it sound like I think I overstated my understanding of the evidence in this case. And what I heard the state say is that they understand he was having emotional difficulties, but I didn't hear anything about counseling or treatment. Or am I missing something? Or?
No, but I did represent that we're trying to get a summary from a physician who talks about his PTSD and both the physical and emotional aspects of this. And again, you've heard admitted evidence from Angela that he's suffering from extreme PTSD, and that was, without objection, it is the state of the record.
The bailiff's playing Candy Crush.
It's the state of the record. Where's the documents? Where's the background? And if you knew that prior to her taking the stand, if you knew he was suffering from such a condition, why didn't the defense have that material? Why didn't we have that before the court? So the court could vet it, go through it, and deal with it, and give us those documents that the court deemed that we should have gotten. This isn't after the fact analysis. This is something that should have been taken care of well in advance of last Thursday. It should have been taken advantage. We should have taken advantage of that well in advance of the start of trial. I mean, if in fact the victim witness advocate in this office, all right, knew that there was counseling or there was a physician involved or some kind of psychiatric analysis, how about just a declaration that in fact he was suffering currently of PTSD, which we did not know. All right. Guess what? I would have been filing the motion. Any defense attorney would be filing a motion to determine whether or not there's something in those counseling records that would have exactly gone to a defect or a condition, or whether it would be impactful with regard to credibility, the ability to accurately recollect. I mean, all of those factors. But, if this thing is sprung out of nowhere, and it's just an acute thing, and there's no anticipation anything like this would happen, that's one thing. But right now we're hearing that that's not true. That there's been a concern for some period of time that hasn't been communicated to the defense or the court. That's what we're hearing. And that's a problem. That is a fundamental rights problem that was decided in August of 1992 in Gagnon's case. That goes to the heart of being able to be on the same level with the prosecution and examining witnesses and getting information and making sure the court vets it properly so that we can come to court and cross-examine properly. Now that wasn't disclosed, and I want you to add that to the motion for mistrial as well. That was not disclosed. So if we're standing here at 11:28 on Monday, the 17th, and he's suffering from a psychiatric condition that we don't know anything about, that the defense doesn't know anything about, that amounts to cause in and of itself. I mean, that's material that would have been used during voir dire. That's material that would have been used during open. I mean, we're discovering now. So, with regard to his mental condition, one, we deny the offer of proof. Two, if in fact there is a condition, we haven't been supplied with that information, we make that demand now. I can make the offer of proof that we never got anything like that. And if we did, you would have had a motion before you so that you could review the psychiatric records and determine whether or not they were material, exculpatory, etc., in compliance with GAG. So please add that. And I also state that the state's voir dire on March 3rd, 2025 got into serious bodily injury, threat of serious bodily injury, threatening, deadly force, self-defense. Let me assure you, Your Honor, if this was a victimless prosecution, that is an area that would have been delved into as well. Not only for the state, but of course for the defense. And we never got that opportunity. So voir dire is very important when you're selecting a jury so that you can properly vet for what you anticipate is going to take place during the course of trial. So we were denied on voir dire psychiatric material and the ability to discuss a missing witness if in fact that would have been dealt with prior to trial. And quite frankly, it could have. We could have been addressing all of this prior to trial. But Friday came along, and again, unless it was a complete surprise to the prosecution, then I would state that the defense has been cheated out of an area that we could have delved into and dealt with on voir dire and open. And in fact, it would have changed certain categories of where we would have gone. Now on, how about Judge, that would have been part of us asking the court not to allow, all right, that video to come. Right. If he was so destroyed by something like that, if we had information that something like this would have triggered it, do you think it would not have come to your attention? I argued that it was prejudicial, much more prejudicial than probative. I think the court would have started tipping in my direction if I also could have played the chip that it would destroy the alleged victim in this case and render the alleged victim incapable of testifying in trial. But I didn't have any background on that. I didn't know. I know that
He's throwing everything at the wall here.
Was certainly recording it and running it live. I also know that the alleged victim probably has a television set, and I would imagine that he's probably watching it. In fact, he may be watching it right now. That's what I'm saying, and there is no sequestration of an alleged victim. We all know that.
Right.
So I think that would have also come into play. All right. Or it may have, but it certainly would have been part of the argument. But again, the voir dire was part, and then the opening, so we're devoid of mental health information. That they were devoid of a missing witness possibility. They were devoid of all of that now has become real. It's part of the case now. We're talking about it right now at 11:30 instead of on the 3rd of March, instead of on the 12th of March. We're talking about it now. That's not the way these things are supposed to be running. And that goes to the mistrial aspect. That's the problem. It's only going to get worse. I mean, if I ask you now, will you order all of the psychiatric and medical evidence with regard to Kyle Violet, and 15 minutes from now we get a stack of it, and it's got psychiatric material in it that should have been given to us, we all know where the case is going. Right? I mean, is this an after the fact? Am I supposed to find out about this stuff next week? Is Jason supposed to become, somehow finally knowing what the case is about after it's tried? No, all this stuff's supposed to happen beforehand. There's a significant disadvantage here. But I have to say, I go back, we'll go back to Ramos now for a second, okay? I want to go back to that because I have this almost vivid recollection of that case. I know exactly where it happened. Right? It was in Manchester. It was on the west side. All right? It was an awful situation. And Ramos, in that particular case, you'll see, there's a real clear indicator in that case as to what the facts are. There's nothing like this. I mean, that was not a witness that was particularly aligned with anybody. This particular case, there clearly is. And to say, well, the defense could call that witness is insanity. I mean, that's an alleged victim who has a completely different look upon this case than we do. And it was posited that he was a victim. He is not a victim, okay, as far as we're concerned. So, I mean, right out of the gate, we have different views of what's going on. And we look forward to his testimony because, quite frankly, when he did have that little soft interview with the CAC people that was witnessed by the detective in this case, he downplayed it like he was just going out there to say hi to his neighbor and please don't, put snow over on my driveway. That's not it. That's not what happened. And he said more. We would have adduced more than a conditional threat. And in fact, we stated there was more than a conditional threat. We took issue with that. Not only was there a threat directly to Jason, but you heard from his daughter the other day, there was a direct threat to her. She heard him say, I will kill you, and I will kill your son. And we were much more prepared to go into a lot of other areas, but he's not here. They're not going to call him. All right. If we would have known that, certain things would have been produced in different ways. But all I got to say, Judge, is this is a unique situation. I have never been thrown into this at all. And you've been practicing a long time in a lot of different jurisdictions, and so have I. And so is Attorney Barth, so Sarah. I'm just saying, unique situations have to have unique conclusions. And going forward now, with the specter of a psychiatric problem from a witness, and the base of the missing witness is that he has some kind of a trauma that hasn't been explained or delivered to the court or to the defense in the form of any competent medical evidence. That's not going to cut it. I mean, that's way off base.
All right, thank you. Attorney Barth, do you want to speak to the Gagne?
Yes, I do. I think this is sort of a confabulation of Gagne with one prong of the missing witness instruction, which is availability. Gagne would be, look, there's a criminal event or an accused criminal event happened, and there are issues about actions, perceptions, behavior in the course of that criminal event. And Gagne is a discovery mechanism to revisit generally speaking, a witness's, particularly a victim's state of mind, condition, during the course of charged conduct is our standard application of Gagne. That's different than saying, look, a witness has an emotional reaction predicated on issues that happened during the criminal conduct. There's nothing here where we're saying, Mr. Violet walked out of his house and engaged in certain conduct because he had PTSD, and therefore the defense should have records to assess that claim about the offense conduct. That's Gagne. This is literally a fluid situation on the eve of trial where revisiting these issues has had a consequence to a deeply, seriously injured person. I made an offer of proof about his witnessing that medical interaction with Hurley. Let me just say, these notions of the defendant's objection based on prejudice have nothing to do with this. The jury, no member of this jury that was lying on the street dying from 6 gunshot wounds in that scene. It was only Mr. Violet. And he has every right to view that material, whether it was from court television or our own expectation of presenting it as evidence. He had a right to see it. He did see it. There was a consequence. You don't want to accept that offer of proof? I get that. just simply declaring I don't want to accept an offer of proof, though, isn't the same. It's State versus Dodopoulos, I think, where the court has commented on offers of proof at a bail hearing. When's a defense entitled to more? I think the court needs to make a finding that there's some basis in the context of this particular analytical framework, which is different than analyzing a victim during the course of an offense, and whether or not you need more to make a decision about the missing witness instruction. And that, again, I'll repeat that the Gagne framework isn't a necessary component for you to make the decision about the availability of the witness. And if this is contrived, this witness is not uniquely available to us, not willing to waive, for instance, a spousal privilege just for us to advance our case. This witness is available to the defense to call, certainly at their peril. But this prong, I think, is being really misstated in terms of a Gagne discovery type analysis. I'll return to this.
I think that's the strongest argument defense has.
Impact of the absence of testimony. They are claiming, on the one hand, that what he would have recast fundamentally is whether or not there was a direct threat, because the defendant, Jason Levesque, has always said there was a direct threat, and his daughter got up here and testified there was a direct threat. That's just not true. Daughter got up and testified, I heard something about the snow, and then I heard a threat to me and to Jason and his family. That was a condition, this is the threat. And by the way, Jason Levesque gave a detailed statement the night of the offense repeating the threat, probably 5 or 6 times, all stating a conditional threat. And so what the defense hasn't been able to do here is say, if only Kyle Violette were to testify, we'd get exculpatory evidence out. And they've never made that claim, not in their motion, not in their argument, not in revisiting the impact of prejudice here. He would have got up and delivered to us that it was a direct threat. There's no offer of proof. There's no basis to say that. It doesn't exist. And so what they want to do is put him up, have him say that it was a lesser threat, and then by just comparison impeach them. But what they can't do, for instance, is say, Mr. Violette would have claimed that he had a weapon, for instance. There's no weapon found at the scene. Mr. Levesque has never claimed there was a weapon at the scene. Didn't say, nobody's claiming, what he would have said is, I've got a weapon here and I'm going to use it, and brandished it. We see on video that he isn't brandishing anything. And Mr. Levesque has never made a claim in the course of that interview. In fact, he specifically disavows it. I could see his hands, didn't have a weapon. And so where is the exculpatory evidence that leads to the notion of both prejudice and fair inference? If the court is going to give an instruction on missing witness, there's another ground, and it's in State versus Rubo, R-U-O-B-O. And I suffered through that case on the defense side of things. Didn't work out well. But there it was the court made the neutral missing witness inference, which is, hey, look, this witness is available to both sides. In reality, not. He had a Fifth Amendment right not to testify. None of that addressed in the Supreme Court case. But the implication was, look, you don't speculate, and that's the go-to rule for absence of evidence in criminal cases. I mean, what are they invited to speculate on? That he was waving a firearm around? It's demonstrably false. Can't speculate about that. Other issues that are provable because of the video and because of substantive statements that the defendant has offered, which we're about to put on into this trial. So, in the absence of exculpatory evidence and an absence of fair inferences adverse to the state, the missing witness instruction without the neutral instruction is inappropriate.
Can I just follow up before you get to that consistent? Back to this offer of proof question.
Yeah.
And I don't want to push you too hard on your trial preparation and all that, but what I understand you to be saying is that the witness was here.
Yes.
Do I take it to be that if you had told the witness you must testify. I'm going to put you on the stand. Was he saying he would not, could not? What was his position, or can you tell me that?
Yeah, look, I get that some of this is work product.
I don't want to get into that. Yeah.
Look, I'll just be transparent. I think these arguments in many ways are fair in the sense of asking for the reality of this progression. And let me just say that, everybody had a concern. I mean, looking at these videos, here's a guy. I've had the same concerns in every domestic violence case where I see a photo of often a woman with serious injuries with someone that, it creates additional trauma that's non-straight trauma. From the beginning of that case, I wonder whether or not they're going to be able to testify about it or willing to testify about it. Right. So this case, we clearly had our eyes on from the get-go. I've described that progression of police going out to his residence, being declined interviews, and eventually agreeing to be wheeled into on a wheelchair into the CAC, by design setting to address situations like this. Then, closer to trial, reaching out and visiting. He's clearly in a state of distress, not one where I concluded he wouldn't testify. Not one where I concluded he would not testify.
So you're saying he would have if you...
At a certain point before trial, our assumption was, look, we're going to just get him here. He was under subpoena. He wasn't running away. Then it got to the point where he was starting to appear quite distressed. And at one point said he could not testify, would not testify, and then received a communication that says, no, he's going to testify, he's able to testify. In other words, this was not linear. Right. And so after that, it was this oscillation during the actual trial period where he was clearly being affected by the process, by revisiting evidence, and at no point, though, can I go back and say, geez, we reviewed documents about his treatment for PTSD. That simply became apparent to us during the course of literally ongoing trial preparation, during trial, And I think that's fair to Mr. Violet. I certainly, want to characterize this appropriately on his behalf. He deserves it. But on the other hand, I get the feeling that this is somehow a late-stage sandbagging effort. It's not. I thought our disclosure was appropriately timely in that, hey, this is it. And by that point, it was, Friday afternoon. We got to put him on or not. And it was not.
And I guess I don't mean to push back on this again. I'm not trying to suggest you're sandbagging. I'm just trying to make sure I understand the facts. When you got to Friday and the decision was we can't put him on, that was my understanding. That was your decision. Do I understand that correctly?
Yeah, my decision, but his statements by that point was that he was not in a position to testify. We revisited it, or we more broadly inquired with, say, Angela, and said, look, he's a wreck in terms of responding to, I think I've mentioned the body cam image of him dying in the street in front of his place. And so I feel like we took necessary, appropriate assessments, both with him, no, can't testify, his wife, he can't testify, but we don't have, some sort of PTSD evaluation and some clinical assessment of consequences to his medical and emotional well-being.
Defense might have an issue here.
I don't have that.
Okay, so I'm just trying to make sure I understand, because I think there's a distinction between saying I, as the attorney, sort of made the decision that I think this would be bad for him, or on balance would be so harmful to him that I wouldn't want to put somebody through that. That is a different factual scenario than a situation where the witness is basically telling you, I cannot do this.
Both. Okay. I mean, I've had plenty of witnesses who have said, I can't do this, and we do a approach. Let me ask you this question. Get an answer. Let's do it in the courtroom.
Right.
Get an answer. What do we do with sitting down? Get an answer. We didn't get there into a progression of a highly traumatized victim. We've all been there.
I understand. And again, not trying to intrude on your work product, but were you able to do sort of, I don't know if you do this or not, practice sort of directs with him? Was he unable to do that? Was he unable to do that?
Yep. Okay. I would pose certain questions, and I concluded that I could not sustain an inquiry about the actual events.
Okay.
And I'll return to this. You can find, if he's not unavailable, then by definition he's available to both sides. They can go ahead and call him, go through this exercise on their own. But I'm not in a position. I agree to offer what I would consider to be conventional evidence of here's a declared unavailable witness by virtue of this analysis from a qualified third party.
Right.
Not that as lawyers assessing an ability to conduct an examination doesn't bring some, I think, appropriate perspective to this. But I agree that this is a kind of a hybrid situation. My representation is I could not and will not call him. If the court concludes, by the way, for purposes of this analysis, that that's insufficient to declare him unavailable, I said, fine, put him up.
Okay. Thank you. Attorney Sisti?
Back and forth.
That opens up other evidence.
The defense has an issue here. It's a small one.
It was like, just what material did you have to come to that conclusion? What exactly were the specific conversations? On and on. I mean, again, I want to make sure that my position that it's unshakable in that we don't accept the offer. We just don't accept it.
Well, I mean, you're not questioning Attorney Barth's representations about what his conversations with this alleged victim? You want me to not accept counsel's representations as to a conversation he had as an officer of the court? You think I should not accept that?
I think that he has opened up for you and invited you to go into the specific conversations. Yeah, I think he has. And he's invited us to do that.
Oh, I see.
But what I'm saying is, if it was 13 seconds of this, what we just heard, then no, I don't accept that. I'm sure it was much more. Okay? But the other thing that we also heard was we shouldn't speculate. And yeah, we shouldn't speculate. And if you're going to come to a conclusion of whether or not somebody's like medically in a trauma, all right, or psychiatrically unfit, it doesn't come from people with JD degrees. It comes from other people with specified medical or psychiatric training. And we don't have that. That's not before you. You can't just...
Should have been a doctor making the call.
I challenge that. This is not a bail hearing, okay, with offers of proof. In fact, in bail hearings where there's offers of proof, and you make a representation that somebody's mentally unfit, well, then usually you make that representation because you reviewed a certain document. I mean, you understand that, right? You don't just say, well, I'm making a decision, I'm not going to call. I'm not going to call. It would be inhumane to call. Right? That's not the test. The test is, on unavailability, you're devoid of critical information to come to that particular conclusion. You were on the right track. What you're really asking, Attorney Barth, is whether or not it was tactical, right? Whether it was a prosecutorial decision, or whether or not he just declared him not a witness anymore. Maybe because of good reason. Maybe because he felt bad for the guy. Maybe because he wasn't acting perfectly okay. I wouldn't know that. I wasn't there. Because he's not equally available, quite frankly, to us. He doesn't come to my office. I don't have people that were reaching out to him. We were totally...
That's not what equally available means, though.
Let's keep this thing on the right tracks. The availability, all right, is clearly leans in the direction of the prosecution. They were He's sitting down with the prosecution. He's discussing the case. He's discussing what he saw on television. Sounds like he's pretty cogent there. Sounds like we're having quite a discussion in a courthouse where there's a courtroom, where there's a trial going on. Right? And he's not here. And I didn't hear that he just flat out said, look, I don't care if you call me, I'm just not going to testify. I didn't hear that. I heard that there was probably a decision that was made by Attorney Mark. I respect his decision. But again, it's one that you can't just accept and say that now he's unavailable. Okay? You can't make that connection. We never had the chance to even challenge that. And you know, if you're going to say he's like an incompetent witness or something like that, the presumption is he's competent until you can find him otherwise. Right? I mean, that's a basic 602 rule. There's nothing to that.
Yeah, but a court issues subpoenas and then the doctor can testify.
What we're dealing with here is speculation. You're speculating that he wasn't able to testify. Could have brought him in. You could have questioned him. You could have questioned him. I mean, it's one of those situations where it's not even adversarial. It's up to you to determine whether or not he would be a competent witness at that point, not the prosecution. It's up to you. And that's part of the rules of evidence. But if they bypass the rule of evidence and just pull the plug on the witness, then it's up to them. Then it's up to the state. Then it's their decision. And if they're making a decision like that in the last second before the weekend, when the case is almost in, other than him and one other witness, then, you know, we should be getting some notice on this. And again, I'm going back. This isn't some, and I don't think, frankly, I don't think the prosecution is trying to sandbag us. I don't want that impression to be made at all. What I do want to make the impression of is that there were other things for us to do in this case if, in fact, this issue, okay, would have come to our attention. And if it came to the state's attention that he was having a major mental problem prior to trial, that's something we're supposed to know.
That's the strongest argument they have.
Supposed to know. That's something we're supposed to work out before we swear a jury. I mean, in all fairness,
fries are done.
You know, it's one of those words that really is kind of overarching here. We were denied that opportunity. I was denied that opportunity Friday. I don't know where he was. I mean, when we went to the bench, I don't know if he was in the courthouse or if he was at home or in a counseling session. I have no idea. But I mean, it's too late. You know, the horse is out of the barn. And if there's unanswered questions about him and whether or not they should have declared this situation earlier, then it's too late. We can't put it back together now.
Counsel, from the state, anything further you want to add?
Yeah, I just, again, want to reiterate that there's a difference between finding a witness incompetent and unavailable. You know, I can go into greater detail. I suppose in my interactions, no, it wasn't this lucid. So how do you feel today? You know, feel like testifying? No, not really. You know, that's not what's going on. But again, you know, if this will take literally an evidentiary hearing to satisfy the defense, I don't think that's what the analysis is in this instance. It is a representation that we are not calling a witness, and the defense has decided, likewise, a witness on their witness list. They're saying they're not calling. I guess at that point puts it just as this unavailable witness, and you go to a second-tier analysis, which is what's the nature of this evidence? It's cumulative. What's the representation about his absent testimony? It's not exculpatory. You haven't heard that. Just that we would have made sort of unspecified tactical decisions differently during voir dire. I'm not sure that's appropriate. And that certain statements that I made came from the defendant, simply not true. Excuse me, came from the victim, that's simply not so. I think we're left with a more conventional missing witness analysis than this Gagne incompetence issue. I have offered by way of explanation, but it's not what the state rests on. We're not calling him. Defense isn't calling him. They shouldn't be allowed to invite speculation through a legal instruction.
Okay. I'm going to take these matters under advisement. We're currently scheduled to start at 9 o'clock tomorrow morning. I'll work on doing my best to get an order out later today so that you all know where we're headed. And
Can I just, to the extent that it is even relevant, we are getting communication from our victim coordinator that a doctor is issuing a letter today. I don't know from what. I don't know that we'll even submit it, because my analysis is that we're not here to prove that he's an incompetent witness. But I'll wait to see when we get it. If the court wants it, the defense wants it, we'll obviously provide it.
Do you know which, from his GP, like from a general practitioner, from a...
Your Honor, I can represent to the court, it's my understanding that this is coming from a physician that has been, I believe, involved in the victim's care for quite some time. I don't know if it's the only physician he's been seeing since the residual, since the incident occurred, but it is a physician that he has been seeing.
Okay.
Well, I'm asking too much to assume, but I want all of the medical records.
Yes.
I want medical records, I want psychiatric records.
What I'm hearing from the state is they're not aware of any psychiatric records, they're not aware of any psychiatric treatment, they're not aware of any counseling treatment. Am I correct about that?
Correct.
All the above, and that we object at this juncture that it's not an appropriate GAGNY proceeding. If the defense wants to file a GAGNY motion, we'll respond.
Yeah, we will, because you referenced specifically that PTSD, from what I understand, is a physical condition. It is a psychiatric condition. So that's a good faith representation on my part to ask for his mental health.
I can represent to the court, it's my understanding this letter will be receiving is going to include some information, potentially an explanation for that. Again, it's not from a mental health professional, but the letter that we anticipate receiving will likely address that in part. But again, we have no knowledge of counseling records or any specific kind of mental health treatment that has been referenced.
All right. Obviously, I encourage you to share it with defense counsel when you get it. If you decide it's something you feel the court should see, if either side feels it's something the court should see in making its decision, please get it to the court as soon as you can. Otherwise, we'll try and get the order out. Thank you all very much. Appreciate the arguments.
Just to request practically from the court, Your Honor, since we're still dealing with some technological issues downstairs, if it would be possible to in some way alert the office and pick up a copy of it, of any order in person. I know we'll be here.
We'll get it to you.
Thank you. I just wanted to make sure we're all on the same page.
We'll get it to you in paper.
Old school, but works.
Appropriate 19th century technology.
All right.
You can send it by carrier pigeon, but I don't know that it'll get lost.
Thank you all very much.
Carrier pigeon works. There we go.
Thank you.
So the judge takes all this under advisement. Let me break this down a little bit for you. Yes, I am invisible. It's my St. Patrick's Day shirt. It is it's an invisibility cloak, but it only works from some angles. So you can see me from behind, but not from the front. The state has decided not to call the victim in this case. They've decided not to call Kyle. They say that he's not in a mental state where he can handle that. They mentioned PTSD, but it was a call that was made by the lawyer, not by a doctor. The problem is the defense says, hey, you've given some indication, even all the way up through your opening, that you thought this might be a possibility. And we have concerns about that there was a possibility that he might not be in a mental state. And if you had concerns, what exactly did you know and when, and why weren't we told about it? Because we have to you have to share things like that. And if you knew that there was a mental condition, a mental health condition that's at play here, that definitely needed to be turned over to us, and we could have possibly run our case differently. The defense does not. They've got him on his witnesses. As it is right now, they could call him unless the judge rules he's an unavailable witness. They could call him right now in their defense. They don't want to, but they would love to be able to cross-examine him and bring up this, oh, look at these mental health challenges and problems. Do we really believe? And they would use it to cast doubt on his testimony. And of course, medical records can oftentimes reveal a lot of things that might be beneficial for the defense in this case. Say, for instance, his medical records, and this is just an example. In another case, the medical records of a victim might show that victim has a hothead, a temper, and that he's been in counseling for his predisposition to resort to violence as a first resort. Say something like that. That might be something that comes up in medical records. If there is an issue like that in Kyle's case, that would be helpful to the defense. The whole, hey, you didn't call him, so we want a mistrial because we thought you were going to call him. That's in and of itself is not a strong argument unless you look at it under the you didn't call him because he has this condition which you did not disclose to us. That's more of an issue. So we'll see. We'll see what it is. It is a chess game. Defense is not going to call him, even if the judge rules that they can. I don't think the judge can rule that he's not available without medical a proper diagnosis from a medical physician that is able to make rulings in that area. It might have to be something other than the general practitioner. So the judge will probably, as I'm looking at this, probably come back and say he's available. Call him if you want. And state says, no, we're not going to. And I predict the defense is going to say we're not going to call him either, because you get that victim up on the stand, and then on cross-examination, the state gets to go up and ask leading questions. And he's like, hey, lift your shirt, show us the scars. Where were you hit? Where? Here. Yeah, that's right in front of the jury. And it's one thing to see a video, and it's another thing to see a person in a wheelchair showing you the 5 different places where they got shot. So I don't think it's going to go that way. The defense does not want to call him. We've seen that play out before, and I would hate if he does suffer from PTSD and the judge does not give him make him exempt from being called. I would hate to see him on the stand. That's just like harming him again. Kay in South Carolina for 26 months been a supporter, says, I'm in Savannah celebrating St. Patty's Day in an Airbnb built in 1908. It's like my house. Shamrocks to all my addicts. Thank you very much. Kay, thank you so much for your support. OG. We've got a few others that were on the OG list. Tower Hill Girl this morning, 24 months for you. Judy M, almost there, 16 months. Thank you very much. May I hold the bunny for my milestone chat? Wallflower, 25 months. Thank you very much, Wallflower. Appreciate that. And Selena K, thanks for giving us an update. MRI scheduled for March 27th, so it leaves me in limbo. It's really getting hard physically and mentally. I am sorry. I saw some of your updates. I know just moving around is difficult, and not moving around is difficult. It's terrible. 10 more days. Hopefully the pain level drops a little bit. Let's see. So where we are today, the jury is not there. We have had some issues with computers in the prosecutor's office and possibly the court as well. So things are not going quite as they should. We're going to jump back and see something that happened this morning, though, instead, right here. Let's see if we can get there. Is it in 6? I think it's 6. Here we go. This is what happened this morning in court as people were filing in. I have to go tiny in the corner because it gets crowded in here.
Hello.
Hello.
Hi. I did it wrong. I ended up calling on my regular phones, and I try to connect on the Google Meet.
How many people are showing up for court? Somebody's like,
I don't know. So do I still, even though I didn't do it that way, can I still have court too?
Can I just?
Are these the clerk people?
No, this is
yeah.
Oh, is you the clerk people or is you the regular person?
Regular person.
Oh, we is too.
We're all regular people too.
What the heck?
Come on. Yeah, come on.
Look how busy court is.
A lot of people here.
Lots of people. What should we do?
Share fire, sir.
I think I just got hit too.
Hello?
Hello.
Hello.
Hello. Have they started yet?
No.
Oh, okay.
All right, if I could get everybody just to be quiet for me. I'm going to go through some general rights that everybody has. I'll need you to listen carefully.
Judge's top left corner.
Can't be quiet. I'm going to have to mute everybody. Okay, so everybody be quiet.
Sorry.
Each one of you have the right to have a trial in your matter. If you decide you want a trial, you have filing rights. You have the right to have a trial before a judge or a jury. You have the right to act as your own lawyer, retire lawyer to represent yourself. If you decided to plead guilty, you'd also have the right to have a lawyer present at the guilty plea. If you cannot afford a lawyer and you're eligible, the court would appoint one for you. You have the right to subpoena, call witnesses of your own at trial. You have the right to confront and question under oath any witnesses called against you. Also have the right to testify at trial or not to testify at trial. If you decided not to testify at trial, would not be held against you. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. What I'm going to do is I'll take a brief recess off the monitor. I'm going to sort through files. If you're not represented by an attorney today, let you speak to one of our court-appointed attorneys. They'll go through your matter with you, any possible resolutions, and then you'll come back and see me, okay? Other than that, just stay right on your device. You're going to be moved around a little bit, but don't move from where I put you, because you'll end up in the bottom of the roll call. So it'll just save some time. Just stay wherever I put you. It'll feel like you're kind of by yourself, but just stay right where I put you. Okay.
Okay.
And with that, I'll just take a brief recess. We'll start in just a minute or two. Okay.
No problem. No problem.
Guys.
All right.
Yeah,
so
no problem.
What could possibly go wrong while the judge leaves, I don't know, 40 of us in Zoom chat together with all our mics unmuted? Where should I go? Is there a good place I can be? Let's see. Maybe I can squeeze up to the top corner.
Thank you.
Go up here, about right here. I can squeeze between these two.
Hello.
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 Good morning.
Good morning.
Good morning. How are you
Good
doing?
morning.
Good morning.
Okay, thank you.
Hi, John.
I am an interpreter for the court.
Good.
Oh, what language do you speak? I'll be down here in this bottom corner. Doo-doo-doo. We'll just chill out here for a while. Trust me, things start popping. Attorney Carter's here. That's nice.
So your mic is muted. It's unmuted.
Yeah, we can hear you.
The video is, I don't know what happened.
Let's see. Jeff's in a car. Bottom left-hand corner. Ebony Caldwell's definitely at work. Destiny Smith's in her kitchen. I think Kevin Morris has us in the bathroom.
You said you tried. You too.
Patrice is having a conversation with somebody in the room with her. Unmuted. iPhone there, top center, second one down from the top. Needs to probably remove his hat. As does Marcavis Edwards. Let's see, who else? I think that's it. Mr. Caldwell's background is blurry. Everyone's getting moved around. Ooh, look at the green. Donald Eubanks. Your client, I'm pretty sure that's not Donald. She looks fabulous in a full green outfit for St. Patty's Day. Not a lot of green on some of the other people, though. Looks like 1+ in the bottom row, one in. Might have a green headband on. Not seeing a lot other than that. You watch this kind of channel daily. Just wait, they're going to start talking. Some people don't handle silence well. The judge left everybody unmuted. Oh, who's got the cat? Heaven's got a cat. Look at that. Top row, second one in from the right. Trying to score some points early with the judge, seeing if he's a pet person.
What's this?
What is this?
This all together?
Mr. Samsung here is just having a conversation. Middle row, second one in from the right, lady in the black and white. What are those two green spear things pointed at her? Is that like a plant? Are we looking at her from underneath like an aloe vera plant or something? Welcome, Ryan. How you doing?
They shooting us around everywhere, huh?
Yep. Ooh, Ryan, top left, having a bit of a smoke. Court can get on your nerves. I see that. Oh, sing it. Mm-hmm.
Is the judge on somebody else's case or something?
Yeah, it's like they bouncing everywhere, ain't they?
Yeah, because I seen the judge and at first I didn't hear what he was saying.
Yeah,
so
I seen the judge and now I'm seeing like all kinds of different people.
Yeah, I'm like, what's going on? I ain't never did no stuff like this. This is my first time.
Yeah, I never did this one either, so it is what it is, I guess.
Yeah.
So, but anyways, though, everybody, I hope good luck to everybody. I hope they have some good luck.
Oh, yeah.
You got it.
Hello, good morning.
Good morning.
Good morning. Good morning to everybody, I guess.
Right.
Lots of fun.
So
I love it.
What's everybody in for?
Maybe
I've been on here since 8 o'clock. Yeah, I've been on here since 8 o'clock.
That's what, a humble brag?
Waiting for this.
Wait for this.
Oh.
the early bird gets the worm.
Yeah, you gotta get up on me. Yeah. Yeah.
It's a criminal meet and greet. Who said that? Heidi, that's fun.
I know, right? It's like we're seeing everybody.
Good morning.
Good morning.
Good morning. Good luck to everybody today.
Yeah, that's what I said. Good luck to everybody.
Yeah. Good luck.
Somebody's a little talkative.
Hopefully somebody gets some good news.
Yeah.
To Samsung, the Samsung there in the middle, not confident that she's the one who's going to be getting the good news. Move over here. Let's see. Do we recognize anybody here? Got a lot of faces. Anybody you see that looks familiar?
Okay. Can anybody hear me now?
Amy, I can hear you.
Yes. Hi.
Yes, we can. We can all hear you.
I'm like I've been talking, but nobody had been responding to me.
I'm the judge. Everybody not guilty. Go home. You're all right.
I already know I'm not guilty.
Yeah, I gotta stay.
I gotta stay, but I mean, you know.
Yeah, times get tough out here.
I've heard of impersonating an officer, but impersonating the judge? Yeah, he's in trouble.
What?
Trying to find a spot.
Oh, yeah, it was just still on now. Okay. I don't think. Moving for the judge. I don't know. Just stay there.
We're losing some people. That's.
Yeah, we all new to this. We all new to it. It's okay. But we all learning together.
Yes. Good morning.
Good morning.
Good morning.
Can I stay up here? The attorneys there with their clients, they stay silent the whole time. They know this is being recorded.
Hello.
Hi.
The judge is just dragging people from one room to another, moving people around on the list, renaming them.
I guess they kind of like keep moving us around, bouncing us to different spots in line.
It's weird.
It is.
I'm like, what the hell is going on?
I'm seeing all these faces of people I don't know. I'm like, what's going on?
I know. I was like, what am I on now? Something's wrong. I've never done this before.
Me neither. I was so paranoid about it last night, like calling my daughter, calling my friend.
I don't know. I asked my son, "Is this right?" I had to show him, like, "Is this how you get on there?"
That's tragic when your kids know more than you.
I know.
So I'm like, okay, yeah. I didn't know what I was gonna do.
Let's see who made the cut. Looks like Alex Shaw's good. Mr. Ostrander is here. Eubanks looks like a lawyer. Scott Arbigger, one of those is a lawyer. Matthew Norwood, possibly a lawyer.
I hope it don't take all day. But I guess you can't complain. You got to stay home in the comfort of your own home.
Yeah, I know. Have to get dressed or nothing.
Well, actually,
I did just because I didn't cook and everything already. I didn't cook and did everything I need to do before setting up for this.
You cooked this morning already?
Yes, girl. I cooked some cabbage.
Oh my goodness.
I cooked some cabbage and my husband gonna make some ribs later.
What time? We'll be over.
I'll be having corned beef and cabbage later.
Yeah. So I done got dressed. I gotta go to work, so I was like, I'll just do this.
It's a good St. Patty's Day meal. Cooked cabbage.
Do this now and do my little running after this court.
I'll probably take a nap and then I'll go to work later.
I got to be there at 12:30, so I'm trying to get like all my stuff done before getting out of here. And I don't know how long this is going to take, so I was like, let me just go and cook it now. Have it done.
It's a spam call, but I'm not going to take it. We're busy.
Yeah, I just woke up.
I've been up since like 5:30.
5:30? It's way early. Okay, so we've lost like half.
Well, I guess this is standing in line together.
Yeah, I was switching to all kinds of different people, and I'm like, oh my God, something's wrong. I pushed the wrong button. I'm trying to push buttons on here.
I just got myself unmuted because at first I was muting. I was hearing everybody talk. And I'm like, can y'all hear me? And couldn't nobody never hear me. And I'm like, oh my goodness. So I started doing stuff on the phone.
That's just like when I first had got on here. I did not hear the judge. Like he was talking, but I didn't hear nothing he was saying.
Yeah, that's what happened to me. That's why I was like, this is a call my daughter. Like, this is messed up. I don't know how to work this.
Like the whole time the judge was talking, I'm like, what did you say? I don't know. I don't know what you saying.
Yeah. I just want to hurry up and get this over with.
I know.
I don't know how many people. Well, I probably didn't see about
4 or 5 people.
5 or 6 people.
Yeah, me too.
I guess it depends on what line we come up in.
Depends if you got an attorney or not.
I'm still. I guess I gotta plead guilty, but I feel I'm innocent. I don't care. I didn't do nothing. I didn't do nothing. But
I was speeding.
Yeah, no. Well, I got hit, and it wasn't my fault. But I had insurance, but I ain't got no license. But I go get an assessment to get my license tomorrow.
Yeah, I don't have no license, but I don't have no points on my license. I got sued, and they took my license because they haven't got a payment. Yeah. Driving without a license.
Oh yeah, that will make your license relapse if you don't pay a ticket. they'll cancel your stuff in a minute. But yeah, I don't have my license because of medical reasons. But it's been over a year and almost a year and a half. And I've been trying to get it back, but now I'm finna get it back. Well, I take the assessment tomorrow, like I said.
Who else wants to share?
Having stuff to do. I can't be sitting around. I'm like, let me hurry up and get my stuff back because this is ridiculous.
Man, we're all over the place.
This online stuff's weird.
Yeah,
Man, this is so weird. I can't wait until my husband get home to tell him about it. Oh my goodness. It's just taking over. It took over.
I know. That's what my boyfriend says. That internet's they want to do everything online now.
Yeah. And it just sucks for us, especially as middle age. Like, it's like we in between. Old people just ain't doing it at all.
No.
Middle age is like, get with the program or you gonna get left behind.
Yep, that's what he says too. Today's my birthday. I turned 51 today, so
Happy birthday.
Thank you.
My mom's birthday was yesterday.
Happy birthday. But my kids have to show me stuff all the time on the computer.
Oh yeah, mine too. I'm 48. My kids show me all. I thought I was gonna have to go to my daughter's house this morning.
Me too. I was like, if mine ain't work, I told my son, because he's on here too. I was like, if mine don't work, I'm gonna show up at your house.
I know, right? I was like, I got a computer whiz as a friend, and I called her last night when my daughter wasn't answering the phone. I called her like, I don't know what to do. She said, well, download Zoom. Download Zoom. I said, okay. I download Zoom, and they said, well, I can't really do nothing yet because it say join. She said, well, don't push it in the morning. Just do what you got to do. Start about 8 o'clock to get in there. And I was like, okay. So
yeah, I put the app on my phone weeks ago, and I was just like trying it out then. And then today I was like, man, I hope this works.
That's what I was nervous about it too. I said, let me go to bed, and so I get up in the morning and do what I need to do. By 8 o'clock, I'm gonna try to get on. I told her I'm gonna call you if I can't get off. She be up early anyway, so. I know my daughter probably glad I ain't have to bug her on her day off and get her up early.
I guess we're on here right if we're seeing other people.
Yeah, well, he came on here and told us just chill.
Chill. Just chill.
I guess we like basically in line till we get called, and they put us on.
Oh, you're on.
But I be seeing all the little videos on YouTube of people like going to court and they be in a house and like, so some of the people be looking crazy. Like, you still going to court? Please, why are you not looking presentable?
Present company excluded.
Like, this is still court. Some people just do not have no kind of knowledge of how to be presentable, respectable, or whatever.
Hey, Alex Shaw, take your hat off. This is court, okay? Thank you.
Yeah. Now nobody wants to go. Are we in trouble? Alex had to take his hat off.
There you are again.
I'm like, what happened? The lawyer or something came on. I don't know. This is so weird to me. I know. I'm trying. But I guess he was talking to somebody else.
Yeah. Somebody had a hat on.
we was just talking about being, appropriate, dressing,
I know. I was like, I wonder if I'm supposed to dress right on here.
I mean, you're supposed to just be presentable. Like, some of them come, they gowns and just looking crazy. It's still court.
Mm-hmm.
Just because you ain't got to come in don't mean look crazy.
Truth.
But they say I might be hopefully, prayerfully, don't have to worry about it. I'm just ready to get it over with. I'm ready to get the assessment over with and everything.
Brittany was here for a minute, but now she's gone.
I know. Last night I was like, I wish this would have never happened.
Yeah.
Oh man.
You're just trying to get yourself together, and it's always something to come and try to make it up. My car acting up. It'd be a whole lot of stuff.
I know my tire keeps going flat. I need tires. I'm just like, man.
I think I need brakes and rotor. A rotor. My stuff it make a little smell, and then it's like grind.
Like burning smell.
Yeah,
you might
and I
have to
think
get it
it's like messing with the tire
Yep, probably is the brakes
and the rotors though.
Mm-hmm.
I can hear it.
That's going to be a lot of money.
I'm gonna find somebody on the street that's gonna do it. I'm gonna buy the parts, and because you go to one of these brake places or something to do it, they cost too much.
Oh yeah.
I find somebody that know how to fix on a car.
Helps.
I got tired of waiting around for mechanics on the side like that.
Yeah.
Because I don't know.
I know, because they be on.
They be messing around.
And yeah, just be trying to get the money a lot of times. But brakes and rotors ain't like no no hard task.
No. Most mechanics know how to do that.
Yeah, you get somebody to do that easy. Now, anything else, yeah. I'll take it to a shop.
Who's texting? All right, we ready to begin court yet? Or we want to talk some more? Ariel, welcome. Let's see. Jeff's been with us the whole time. Doesn't look like he's driving. That's good. Should be in the passenger seat anyway. Mr. Eubank's talking, but he's muted. Same with Mr. Bigger. The attorney that called out Alex Shaw immediately turned off his camera. Here we go. Who's back? Who joined us? Taylor Bell has walked away from his phone. He's looking up at the ceiling. If I was in court here with these people, what would, well, let me put it this way. If you were in court on Zoom here, what would you start saying to everybody? Would you talk about getting a lawyer? Would you talk about don't say anything? Would you ask what everyone is here for? We're losing people. I think Amy's either frozen or fell asleep. Oh, there's a cat. Cat in Samsung, top left-hand corner. Just walked down the hallway. Wouldn't say a word. Would talk about the judge. Waited over the weekend. I would exercise my right to remain silent. I would mute. Sit in the corner and observe. Would shout out Law Talk with Mike and Recovery Addict, says Mr. Pancake. Would mute and watch Ari on another device. Would hold my cat to the camera for the benefit of all. Shark, I think that's proper etiquette in any Zoom hearing. It's to introduce your pet. Be finding out where those ribs are.
Yeah, I guess it's gonna be a while.
Yep. I'd give an impromptu. I think I would probably.
I figured it'd be at least a half an hour because don't the judge usually come in about 9 o'clock?
I was gonna say about at least 9:30.
I would treat it like it's a
9:13 right now.
TED talk, and I'd give a TED talk because I had a captive audience.
I know I didn't go to sleep till 5 in the morning. I work second shift, so I'm used to being up.
Yeah. I had got another ticket like 2-3 weeks ago.
Oh my God.
Going down the
I
street.
haven't had a ticket in like 9 years.
And I mean, I'm on my way to my granny house. It's early. It's probably like 9. Well, the facility she stay in, to give her a shower. My granny is 98 years old. I'm just trying to go help her give her a shower. And I got stopped. And I think I was going like 40. He said it was, I didn't know, I thought it was 35, the speed limit, but he said, no, this is 25. I said, oh. I hurried up and paid that ticket before court, though. I said, let me at least have this ticket paid.
Mm-hmm.
I don't even want that to have to even come up. I said, man. And that's what he gave me the ticket for. He just gave me the ticket for
5 over.
No license. Was it no license or speeding? I think no license. He gave me the ticket for no license.
And he let you drive off?
They're stopping everybody up there by the expressway or by the airport.
Oh, for real?
Yeah. Anybody doing anything wrong, speeding through there, they're getting them. They got all my kids and me right there in Vance Lake and Bristol.
Oh, right there.
Yeah, that's where I was at too.
Man.
Yeah, you can't speed up there at all.
Oh, they be going fast right there too. But what is that? Ain't that like 40, 45? Or what is that?
40. I don't know.
I think Vance Lake going up to that in Bristol, I think that might be like 35. Cause the shop right there.
I think it went up to 40 when I looked at it last. It was 40.
Yeah.
Yeah, that they're pulling everybody out of the shop. Then people got money over there.
People come out the shop, they be zooming.
Oh,
My
yeah.
mom worked in the shop. Like when them gates, once they got start where they couldn't leave for their breaks and stuff.
Yeah.
People come up out them shops, they be running to their cars.
I know.
Out the parking lot.
My daughter works there, and when it's time to leave at night, they hurry up and run to their car so they can get out of there first.
Yeah.
It's crazy.
I'm like, what? Like kids.
I can't believe they don't run into each other.
This is like kids when you get out of class in the hallway trying to run down the hallway.
Yeah.
The hallways get full. I used to tell my mama her job wasn't nothing but a big old school. Because all the drama and all the stuff they used to go on.
Nobody wants to eat that school lunch.
Don't nobody want to eat that school lunch. Everybody trying to go. They stopped them from doing that. My mom was so mad.
I went to Whittier. I always say they had real good school lunch.
Oh, you went to Whittier because so y'all went to go get pizza and stuff.
Yeah, they had pizza and
There's a lot of
fries
pizza.
every day.
That's what I'm saying.
They had good lunch. Now the lunch is nasty, I guess, everywhere.
Yeah, I went to Southwestern. That stuff was. I mean, lunch was lunch. I used to just bring me chips and stuff.
Yeah.
But the pizza, yeah, like you said, pizza day. Everybody don't eat on pizza day. And the fries, you gonna get you some fries.
I want to say they had it almost every day.
Yeah, because really them days, you know, when we got up in the higher classes, they did certain stuff every day. The fries for sure. I know they did fries.
Love the fries.
Yeah. That's what I always say, man. We had good lunch.
All right, guys. We're on public screen too, so I hope we haven't been talking too much.
Okay.
Mr. Norwood, who do you have? Oh, right here. How
We're
about
live.
Jeffrey Ostrander? Ostrander.
Yep. Yes, sir. Present.
Okay.
All right.
Your Honor, Attorney Matthew Nord on behalf of Mr. Jeffrey Ostrander, who is in Zoom with us. I did have an opportunity to speak with the prosecutor on this matter. He is charged with driving while license suspended. The prosecutor has agreed to amend this down to allowing an unlicensed person to drive. My client would be tendering a guilty plea to that today.
Okay. So you're being offered the amended charge
Okay,
to
so we're gonna
allowing an
bail on this
unlicensed
now.
person to operate a vehicle.
That's all we were there for, was just what happened before court. We are going to go back to one we have not been to in a while, though, and that is Judge Stephanie Boyd.
All right, Ms. Ferguson, recall this for
Live.
April 24th for discovery. All right, thank you.
Thank you.
All right, and we have victim impact.
Yes, you got you. Sorry.
And just like that, she went unlive. Well, we'll have to go somewhere else then. Let's see if we can go up to. Where's Dad Judge? Where's he at? Looking. Judge Simpson is not live right now. Chisholm's not live. Oh, here we go.
That prison is appropriate in this matter. So what I'm going to do is I am going to sentence you to 3 years of initial incarceration, 5 years of extended supervision. I will make you eligible for the substance abuse programming after 1 year of incarceration. I'm ordering that while in prison, you engage in mental health treatment and mental health programming. You have a mental health assessment and follow through. You have an AODA assessment and follow through. No contact with victim's family. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. This is a felony. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. If you would like to use any type of weapons, you can hunt. You just cannot use a firearm. You can use a crossbow. You can use a pellet gun. You can use those types of things. You cannot use a firearm.
Bare hands.
And as far as the knife goes, I'm not the legislature. I didn't write that. Whether or not I think that is an accurate law or how it is written, I can't say. I'm not the legislature. But unfortunately, you cannot even have a knife in a pouch because you're a felon. Cannot even be in a pouch.
No knife.
And this is consecutive to your other sentence. No alcohol, no drugs. So absolute sobriety. Continue with mental health once you are released and on extended supervision.
It's spring powered or air powered. It's okay.
Any outstanding fines and fees will be a civil judgment. You're always going to owe them. You can sit more jail time. Ms. Rocca, what am I missing?
Credit.
Jail credit?
Yeah, he had 6 days on the last judgment of conviction in this case.
6 days of jail credit. What else am I missing, Mr. Keen?
I'm Chisora, but he wouldn't be eligible to vote until after his supervision is completed.
Yep, I said that.
Okay.
All right.
Fire.
All right. If there's nothing else, then we are adjourned.
Three-year sentence. I don't know what he did. I can go back and find out if you want us to do that. Let's back up just a tiny bit.
He messed with the crime scene.
Oh.
We're in the shed.
We're backing up. We're going to get this. It's spicy. Let's get the whole thing.
After the incident,
now that we know how it ends.
Let's just Sawyer County.
Let's go forward. He messed with the crime scene. Okay.
Okay.
We're going back.
All right, now, Mr. Reynolds.
Nope, we don't have to go back that far.
CF 2.
There it is. Here we are.
We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. This state appears through Assistant District Attorney Holly Rockow in person. We have Mr. Scheuer appearing in person in custody with counsel Glenn Keene. We're set here today in this matter for a sentencing hearing after revocation. Mr. Scheuer was placed on probation after he pled guilty back on September 3rd, 2024 to 1 count of possession of a firearm by a convicted felon. 3 days after he was placed on probation, he was put into custody for another serious offense in which he was just recently sentenced. He was revoked on this matter due to the allegations and matters in the case that he was just previously sentenced. This matter was set for a revocation sentencing. The court has received and reviewed the revocation order and warrant packet from the Department of Corrections. I have reviewed such packet, and in my review, I could not see any material facts or statements that need to be clarified on the record. But again, I don't know all of the information that the attorneys know to be able to have those material facts and corrections jump out at me. Ms. Rockow, as Assistant District Attorney, are we in victims' rights compliance?
Yes.
Did you review the revocation order and packet in order?
I did.
Any material facts or statements that need to be corrected on the record?
No, Judge.
Is there going to be a victim impact statement made here today?
No.
Okay. Mr. Keene, did you receive and review the revocation order and recommendation packet?
Yes, Your Honor. And there are no facts in there that I believe need to be corrected.
Did you review that thoroughly with Mr. Scheuer?
Yes, Your Honor.
And he did not discover or find any material facts or information that should be corrected on the record?
No, Your Honor.
Okay. All right. Thank you. Ms. Rockow, please begin your sentencing argument and recommendation.
Thank you, Judge. The state respectfully recommends that Mr. Scheuer be sentenced to the state prison system for a total of 4 years, with 2 years of initial confinement, 2 years of extended supervision. That is in line with the recommendation that was outlined in the PSI by the department. As the court's aware, we are to consider the Galleon factors here in determining an appropriate sentence for Mr. Scheuer. The state's position is that Mr. Scheuer must be sentenced to prison based upon the factors. As far as the gravity of the offense, possession of a firearm by a felon is very serious. The legislature indeed has deemed this a Class G felony with a maximum possible penalty of 10 years. It's a crime that poses a serious risk to public safety. This crime in particular, the underlying facts of this case warrant a prison sentence. Mr. Scheuer was at sentencing. There were 4 other counts that were dismissed but read in, including 3 counts of possession of a firearm by a felon in addition to this conviction. There were 4 total rifles that were in Mr. Scheuer's possession at the time of this incident. And on the date of that arrest, he admitted, and in fact, one was in his direct control, very nearby to him, and he had admitted to law enforcement to having handled that firearm in particular on that date. He also had a knife concealed in his possession. So this is an inherently serious crime, and the facts are also quite serious in this case. In terms of the character of the defendant, again, inherent in this crime is an indication that the defendant has no regard for the law. He's a convicted felon, not allowed to possess firearms, and he did so anyway. His criminal history reflects convictions dating back to the early 2000s. He has a fairly extensive history. His history does include violent offenses, convictions for battery, simple battery, and substantial battery, violations of domestic abuse, no contact orders, also includes recklessly endangering safety, and multiple convictions for bail jumping. I'll also note that there's a 2014 conviction out of Minnesota for possessing a pistol or assault weapon.
Pistol or assault weapon?
The need to protect the public is the last factor for the court to consider. And I think that there's an obvious need to protect the public from Mr. Scheuer. A convicted felon with a violent criminal history who shows no regard for the law, no regard for court orders, or for the public, or for public safety. His actions that led to the revocation obviously include more violence, more disregard for public safety and for the law. I think anything other than a commitment to the state prison system would unduly depreciate the seriousness of the offense and the conviction here. And I do think, in fact, prison is necessary to protect the public in this case. Thank you.
All right.
Wow.
Defense.
Your Honor, I do have one character witness for him. It's his son, Brandon Scheuer. He's here in court.
All right. Mr. Scheuer, you can come have a seat over at the black table, and you can state your name and spell it for the record.
Can't see him.
Hello, hear me? My name is Brandon Scheuer. It's BRANDON SCHEUER.
You may begin.
Where do you want me to start?
The very beginning.
Glenn.
Well,
Nope, you just.
whatever you talked about.
Oh, whatever we talk about.
Yeah.
All right, well, I'll start off by saying that, I do think that violent criminals should be in prison. I don't think my dad's a violent criminal. I think that he has mental health issues that were never addressed for the last 20 years. And I do believe alcoholism amplifies those. And I believe getting mental health would help him dramatically. In the case of this issue, I could tell my father was a different person after the suicide. My father always had like a clean counter, dishes always done, up early. I would not hear from him for a couple of days after the incident. I would go check on him. He would still be in bed with a giant body pillow, counter trash, sink full of dishes, just completely not his character.
Giant body pillow?
And I believe that was just more depression. And I think that his depression and his mental health issues have never been addressed. And he's constantly been incarcerated and never gotten help that he's needed. And I think getting him the help he needs is a big step. Is he going to have to be in prison? Yes. But just locking him up isn't going to help him. He needs to get help. And I wish the court system would help more people in this case. It's an epidemic in this country where people are just locked away when they have issues, and we don't address the mental health issues that we need to address.
Preach.
3 of those guns that were locked in the shed on the day of that incident were mine for deer hunting. I had them locked in that shed. I believed I had the only key to that shed. I was unaware there was a second key. The .22 firearm that was used in the incident, to my knowledge, was used for protection against bears as they were living in my camper on his 40 acres. When Crystal and my father first started staying on the 40, they were staying in a tent. They had bears tear the tent, tear the coolers. I gave them my camper to stay in as a safety option.
22 doesn't work with bears. That's like using a
other than
spit
that,
wad to
the only real things I have to say is that I
fight off a
believe
mountain
that this
lion.
country has a problem with just locking people up and throwing them away. And I think that we need to address mental health issues more and more in this country. And this case in particular, he's had 20 years where he's never had that addressed. And he grew up at a time where when people had mental health issues, they really didn't talk about it or get addressed. And I believe most of his issues stemmed after the divorce with my mother in 2003. His alcoholism, which he hadn't drank in many years, had kicked off and came back into his life and continued to amplify those mental health issues. Because when people are depressed, the drinking don't help that. All it does is amplify those issues. And that was never, ever addressed in over 20 years of him being in and out of the system. That being said, I can't quite think of too much other things to say. I know my father is a very good person when he's not drinking. He has donated his time to my business during the parades and other things, and to help me with working with kids in the community for kayaking. He cuts and splits wood. He has helped friends of mine who needed trees removed or other things on their property done come over without even being paid to help out, just to be a good Samaritan. So I know there's good in him. We're not unlocking the good. We're locking the good up with the bad. Where we should lock the bad up and unlock that good. And the only way that is to use, mental health therapy and other sorts of programs to get to the root of the problem. I went through therapy because of you, Judge, and I continued to do that therapy for a while after the things we had with the things I did to get back, and it helped me very much. I'm creating new programs to help myself hydrate more, things like that, getting better eating schedules, just slight things to add more consistency to life and a more routine schedule. And I think, that helps a lot of people. And it's something I needed just slightly to help my life, but there's a lot of people that need a lot more than that. And they need that intense mental care. And that's something this country has gotten far, far away from. And I hope we get back to it.
It's resonated with the judge.
Thank you, Mr. Schroyer.
Thank you, Your Honor.
All right. Mr. Keene?
Yes, sir. When we look at this case and sentencing and the factors, I think a couple of things to note. Well, I won't dispute the seriousness of the crimes because Mr. Schroyer does have a lengthy criminal record. Most of it is for, substance abuse related issues, but you've seen that on pages 24 and 25. So, I won't dispute that. However, when you look at the character of the defendant, I would note that when you look at the offenses that day, his son had just talked about how, the 3 of the firearms were his and it was, a place to hunt in the 40 acres. and he said that they were encased. I would note that my client on the day he was charged, had contacted law enforcement. He, pointed out, the weapon was not was set by the vehicle when law enforcement arrived. He's not brandishing it. And his son had just testified that the 22 was, for, protection for bears. A 22 isn't usually a weapon if you're going to try and rob somebody, a 22 isn't your first choice. And regarding the dismissed and read in on the concealed knife, it's a 40-acre property, and he had it. There was nothing about him threatening to use it.
But I'm hearing excuses. He's a felon. He's a felon, a convicted felon, and I'm hearing excuses. Even in your defense argument, they're excuses.
I see them as mitigating factors rather than excuses.
There's other things to use to protect against bears. I've done it myself. I've grown up in bear country myself. I don't carry a 22 or a knife. There's bear spray. There's crossbows. There's other things that felons can use and carry. It's an excuse.
Well, and again, the firearm was owned by the person who lived there, not him. But I get that when you live with you're a felon, and the person you live with has a firearm, it tends to put you in an untenable situation.
And he admitted to operating it.
Right, moving it. Okay. But I think we did point out in needs is that, the alcohol and counseling needs, and he did talk about one of the things looking at revoked is that unfortunately, mental health needs did increase after that because his son did describe a change in my client's behavior after his then girlfriend, unfortunately, took her own life that day. And, that obviously contributes to a downward spiral as well.
Whoa.
And I would note that, when you look at protection of the public, I would note that, he already, for the offense he was, convicted, pled to in this court, he already had a 9-month sentence. And I think that, allowing him to be closer to his son and the community would probably do more in the long term to protect the community than just simply warehousing him again, which is what his son was saying, because, it access to, counseling and other needs. So the defense thinks that, a reasonable sentence would be 9 months of custody, because he already has a 9-month sentence in 24 CF 202. So if you sentence him consecutive that, then he's still closer to his family and other things, and hopefully could address his needs. And, if he qualified for Huber, he'd be in a confined setting, because obviously if you're, having to go to and from jail or report on monitor, that would be a way of ensuring sobriety, because when for the charge he was revoked, he admitted to having alcohol that day. So having additional time where, if he qualified for Huber and in the community, he could, potentially get counseling. He could be working. He would be monitored on a continuous basis to ensure that he's not having access to alcohol versus just, adding more time to prison. Then when he gets out, it's back to the same supervision that obviously hasn't worked. So I think if you look at those two sentences, because they're both really the same action, you'd be looking at 18 months total custody he would have had. And I think that would promote more to protect the community while reflecting on the mixed character of Mr. Schuler than just simply, tacking on a few more years in prison. And failing that, obviously, would ask that he at least be eligible for the earned release program and for substance abuse. Thank you. Well, I'm saying is if you disagree with our suggestion, obviously one of the decisions you'd have to look at is whether or not he would be eligible for.
He wouldn't be eligible for the challenge incarceration.
No, I'm talking about. No, I'm not talking about challenge incarceration.
For the substance abuse.
Right. Yes.
Right. Okay.
Right. No, I'm aware that, he's 2.5 decades too old for challenge incarceration program.
All right. All right. Thank you. Mr. Scheuer, now is going to be your opportunity to tell me your side of the case, if you wish to, anything that you would like me to know about this case, about this matter, about yourself. I have read the department's revocation packet, which does include a lot of information, and it includes the decision by the ALJ, the alternate or the administrative law judge in the revocation, as well as a few bits of other information. You can tell me whatever you wish to tell me right now, or you don't have to tell me anything.
Well, I'm going to tell you one thing, that the gun was for her. It wasn't for me. It was for her protection. She was a girl from the cities, and she was afraid of the bear. The gun was given to her for her own protection. And it was supposed to be locked in her storage shed, and she had the only key for that storage shed. I don't know how the gun got. Obviously, she went and got the gun, plain and simple. I didn't know. I was at work, and she dropped me off because I worked at the 10th hole. And she dropped me off, and then she picked me up. And then when we went home, that's when she went in and brought the gun out, plain and simple. But otherwise, yes, I myself believe I have post-traumatic stress. I was in shock. I never would want to witness anything like this in my life again. I feel sorry for vets going to war and watching people die. I love that woman. Loved her to death. I moved the gun till the gun fell on her. It's the only reason I moved it. I didn't know if she was going to shoot me. I didn't have a clue. It's the only reason I moved that gun. And the other guns I didn't know nothing about. Yes, I had a key. I had a key in my key ring, but I hadn't gone into the shed. Wasn't in the shed for days. And it was 2 days before deer hunting. That's all I know. And the guns that were in the storage, in her storage shed. And I know my son deer hunts, and he was supposed to have friends come over that didn't have guns, and they were going to hunt. There was no bullets, nothing there. There was absolutely nothing to fire out of them guns that were in that shed. Absolutely, there was just guns. That's all it was. Guns and gun cases. And I knew nothing about them. I knew about the 22 that she had because she asked for permission, and she got the gun from my son for her own protection when she was there by herself. That's what it was supposed to be for. And like I said, I only moved the gun when she shot herself and hit the ground. That's why I moved it, and I leaned it up against the car that was in front of it.
Okay, so wow, this
like my son said, I help him a lot. I help a lot of people. If you even ask the jailers here, I'm cleaning all the time. I ask to move to different cells just to go clean them because they're not clean. I help a lot of people. I buy canteen for people. I'm not a violent person. Yes, I do have mental issues. And with that, yeah, I probably had drink. I started alcohol. I was sober for 24 years. My kids grew up with a sober father because my father was an alcoholic. So when my kids grew up, I didn't drink. But when my wife divorced me and I ran through the coals, I started drinking. That's when I started drinking in 2006. If you look at the records, that's when all my problems started. And with that, that's all I got to say. I wouldn't harm anybody. I wouldn't kill anybody in my life. Like I said, I wouldn't want to go to war. And with that, it's...
How many sheds were on that property?
Huh?
How many sheds were on that property?
One.
I just got multiple stories about the key or who had keys and who had access with that. First, you said she was the only one that had a key.
No, that was her storage shed in town. She had a storage shed in town with all her stuff, and she was the only one with a key for that shed. That's where the guns were stored, was in the shed in town.
That's where your son's guns were stored?
Yes. The guns that ended up on the property were in that shed.
All of the guns that ended up on your property where you resided in that camper were originally in a storage shed in town,
Yes,
but somehow they ended up all on your property on the camper?
because deer hunting was coming and she brought them for my son to go deer hunting. That's how they ended up there. Because it was 3 days before gun season. 2 or 3 days before gun season. It was on a Wednesday. And they were getting ready to go deer hunting.
And then they were placed in another shed that you had the key.
That a key was on my key ring, yes.
So you.
But I didn't know the guns were in the shed. I wasn't home when the guns were put there.
Then how did they get into the shed? If you.
I'm assuming Crystal brought them over for my son to go deer hunting.
But if you were the only one with the key.
No, I wasn't. The shed at my house, no. I wasn't the only one with a key.
I wrote it down. You said I was the only one. I was on my key ring.
No, that's not true. I had a key and there was 2 other keys for the lock because the lock was for the shed and for the chain that went across my driveway down on the end. My son had a key to the shed.
I heard that and I knew that it was his property.
No, the camper is his. The property belongs to me.
40 acres is yours.
Yes.
And he brought the camper for you. So
Yes.
the shed is yours.
Yes.
The guns in the shed were not yours, but you had the guns in your shed.
Yes, the guns were put in the shed, correct. On a Wednesday, and then deer hunting was Saturday. But there was no ammunition for the guns.
How does he know? How does he know there's no ammo, but not know about the guns?
Were you and the victim fighting that day?
No. No.
You weren't drinking together at the 10th hole and fighting?
No. No.
Then what happened that day? What happened where she picked you up?
Crystal was a very depressed person. She was on a lot of medication and she was from Minnesota and she was losing all her medication. She put money in the bank, which I had to remember when I signed the check for forgery and we got all that settled because she had a check that she went to the bank down here in Simon and was going to deposit because she didn't have an address. So she went down to the bank, Bremer's Bank, isn't it Bremer's Bank down there, and tried to put that check into the bank. And they told her they wouldn't accept it because she didn't have a permanent address. So she went to US Bank, which her and I had an account together. But then she moved back to Minnesota for her medication to a Jeannie, and I can't pronounce her last name's house, and changed her mailing address. That's how Crystal's daughter got the statements for the bank, which she put the money in US Bank, and US Bank wouldn't let her take the money out because she couldn't establish a address.
So again, I don't understand how this happened because here we have a day, okay?
Yes.
Where we have the victim dropping you off at the 10th hole to work.
Yes.
And then you
in the morning, and then she went to the food shelf to help at the food shelf.
Can you let me talk, please?
Yes.
And then she dropped you off at the 10th hole.
Yes.
And she went back and did whatever she was going to do that day.
Yes.
And then she picked you up from work at the 10th hole. And you're telling me she didn't have any drinks or alcohol.
Yes, she did.
So she sat and she drank for a while.
No, she had one drink. She had a Bloody Mary.
She had a Bloody Mary. And she picked you up. Did you have anything to drink that day?
No.
So you didn't drink. She had a drink. She picked you up. She brought you back to the camper. You weren't fighting. There was no negativity between the both of you. You get back to the campsite, to your camper, where you both have resided and lived for a significant period of time. And then all of a sudden, out of nowhere, she grabs a .22, runs in front of the the camper or the truck and shoots herself in the head. That's what happened. That's what I'm hearing. Nothing happened that caused this.
Wow.
When we were at the tent hole, there was a girl in there that had black curly hair like Crystal used to have. She used to have long black curly hair. Well, she cut all her hair off and it was pure white. It turned gray. Well, this girl had the same kind of hair that Crystal had, and she had a low-cut shirt. And when she went by, Crystal said, "Look at her hair." And I said, "Yeah, it's pretty." And I said, "She's got a nice cleavage, too," because her cleavage was hanging out. And Crystal used to be the same way. Well, the girl next to Crystal turned to her and said, "Well, I'd like to do something with my hair." So I think one reason was that depressed her because her hair was cut off and it wasn't what it used to be. Crystal committed suicide more than once. I saved Crystal twice before this. One time she took a bunch of pills when we were living in Burnsville.
It just doesn't make sense. It doesn't make sense.
She was a depressed person.
Respectfully, I think we're getting a little, we're simultaneousing for having a firearm, and now it seems like the court is moving to trying to investigate
the death.
What he did though was he messed with the crime scene by touching a gun. He messed with the crime scene. I'm not trying to go into anything. There were allegations, or there was discussion on whether or not there were facts for a homicide, Mr. Keene, before you were even involved. That was part of a plea deal with the original attorney that homicide would be forever off the table as part of the plea deal. The court said that can't happen. That's against public interest. That can't occur. So then that was removed as a plea deal. So the court's trying to understand here. I'm trying to get an understanding of how this could even happen. He knew that there was a firearm, a .22.
No, I didn't.
You didn't?
No, I didn't know it was there. The same with the other guns. That day she must have went and got them and took them there.
And with the bears there, you had no clue that there was a .22.
Yes, but the gun was still stored because the bears weren't around anymore.
You just said you didn't know that there was a gun, but yes, you knew that there was a gun, but it was stored somewhere. So there weren't bears there anymore. There's always bears. We're in bear country.
I realize that.
None of these, I'm just saying, Mr. Keene, none of his statements, none of his facts connect. That's what I'm saying. And I'm trying to connect the facts. That's what I'm trying to do. Is he here for a sentencing of homicide? He is not, Mr. Keene. He is here for possessing a firearm as a felon.
Yes, sir.
And that's possessing is knowing there is a firearm in your ability to have possession of that firearm. I'm trying to connect the facts. It doesn't make sense if there was no fighting, if there was no negativity, if nothing occurred, and all of a sudden some girl with beautiful black curly hair and huge, delicious looking cleavage, and a statement is made that the woman would go and all of a sudden go home and nothing else occurred. She would grab a .22 and shoot herself in the head in front of her significant other without a statement made. It makes no sense. And then the defendant altered a crime scene. He manipulated a crime scene by taking a gun from a person who apparently, allegedly committed suicide. He took a gun and moved a weapon. He touched evidence. You do not touch a crime scene, whether it is determined a suicide or it is determined to be a homicide is not for Mr. Scheuer to determine. It is for the police to determine, and they were not given an opportunity to make any determination, and because he altered it. He altered the evidence.
People panic at various times and react in.
Exactly, but they cannot touch evidence in a scene. And here's the thing, again, we're digressing. I'm getting to trying to figure out that day and what happened and why we are here and what I am sentencing for. It is not simply a felon possessing a firearm. And as you stated, and that was part of your argument, there's bears. So you need a gun to protect yourself from bears. And that's why he had the knife, because he needed to protect himself from the bears.
The knife, the knife wasn't about the bears. It was just, if you're on a working property, a 40-acre property, you're probably going to carry a knife, have a knife on your property in the country. I mean, make cut branches, whatever. Just making a point that although it was a dismissed and read and charge, there's a difference between carrying a knife in town and around people versus having one on your own property.
I get that and I understand that. But again, that's where I'm trying to connect the dots and I'm trying to see where we are, because as you can probably gather, this is a very serious case. You're arguing to have him released and just have him sentenced on the case that he was sentenced to, which again was very serious and serious domestic.
My argument was that since you'd already ordered that one to be consecutive, I was suggesting for a 9 months county sentence, because you'd already in 24 CF 202, you had declared that one to be consecutive to other cases.
Mm-hmm.
So I wasn't suggesting that the court, go from 2 to 3 years in prison as the DOC recommended, or the state's recommendation of 2 years in prison to, in essence, time served. I was arguing that, an additional 9 months in county jail that was consecutive to 24 CF 202 would be an appropriate sentence for
18 months of jail. And then otherwise we have the recommendation from the state of 2 years in prison and 2 years of extended supervision, or the recommendation of Department of Corrections for 2 to 3 years in prison and 2 to 3 years of extended supervision, and or the maximum possible penalty of up to 5 years in prison and 5 years of extended supervision. When we look at this case, and again, this is why I have to connect the dots and see what happened. And I'm not looking at this as a homicide. I can't do that. That is not what this is. But again, I do have to look at all of the facts.
I want to know why she did it too.
All of the facts as they occurred that day. Every single fact. And I have to determine credibility and whether or not I believe Mr. Scheuer that he says he did not know there was a firearm. And I'm hearing contradictory statements. That's why I ask the questions, Mr. Keene. That's why I ask the questions again in a different way, and then again in a different way. And that's why I asked to connect the dots. Because one time I get one answer, one time I get another answer, when it really is the same question, just asked a little bit in a different way. Stop. So when I'm looking at this case, and originally you're looking at this case, he was charged with 5 crimes, 4 very serious felonies, up to maximum possible penalty of 10 years in prison for those 4 felonies. And a misdemeanor, up to 9 months of incarceration for that. Part of this plea agreement, this working the deal out with the state, you got a really good deal here, because the agreement called for pleading guilty to the 1 possession of a firearm as a convicted felon, and the rest would be dismissed and read in. So the maximum possible penalty hanging over your head is no longer 40 years and 9 months. It's 10 years. So 5 in, 5 out. So that's a pretty good deal, considering the facts and all that led to it. Because again, you could have been charged with altering a crime scene. There could have been other things that could have been charged here, but you weren't. And I understand where Mr. Scheuer is coming from that day of stating that the victim killed herself, took her own life that day. Again, I'm trying to wrap my head around what happened and why it happened or how it happened. With the facts I have, I can't. But what I have to wrap my head around is the actual charge that I have in front of me, and that conviction, possession of a firearm, convicted felon. I do believe that you knew that she had that 22. I fully believe you knew she had that 22. I fully believe that you had access to that if you wanted to. You were in a very significant relationship. As you said, you loved her dearly. You seriously loved her dearly. I don't know if you love her now. I don't know if that was your statement. And you're showing emotion as to her death. And I believe your son Brandon when he says that he sees mental health issues in you. I fully believe it. And I remember Brandon a little bit from a few years ago. I haven't seen him in front of me, so I'm going to guess that he's done a lot of good things with his life and he's made changes and he's doing well. I believe him when he's saying he wants you to do better, Mr. Scheuer. And I believe him when he's saying that he sees a change from when you were raising him and when you were with his mother versus when the divorce occurred and you started drinking again. And that's when it flipped. And that's when the mental health issues, I don't want to say arose, but they grew more intense. And I can see it in the last case in which you were convicted in 24 CF 202 with the individual that you said wasn't your girlfriend, but she thought she was your girlfriend. And that was a domestic abuse incident. It wasn't charged as domestic abuse, but that was a violent act against another woman, against a woman there too, against a person. And mental health issues most likely were involved in that as well. I do believe that you do need assistance, you do need health, you need help, you need someone to provide you with the guidance and the therapy. I don't know how to do it. It's not just AODA, it's not just AA, and it's not just abstaining from alcohol. Whatever happened back in 2003, 2006, and again, then when you started drinking alcohol again, and it started you down a spiraling path, I don't know. Because if you're living on your property, you own 40 acres, and you're living in a tent for a significant amount of time, and then your son has to provide you a camper to live in, and that's through the winters and through, we have hard winters. And if you're living in a camper, it's telling me you're not doing something to get your life on track to be a little bit more stable. I'm glad to hear that you were working at the 10th hole. I don't know if it was full time. I don't know if it was enough to be sustaining or to pay your bills or to have any property or anything other than paying for your 40 acres. But I don't know what occurred that day, and I don't know what happened that day. I don't know if you really did know or have an idea of if your son's other guns were in your shed. You had a key, and if they were placed there on Wednesday, they couldn't have been placed there on that Wednesday, the November 15th. They couldn't have been placed there that day. That would be too coincidental that they were just placed there that day, and then all of a sudden victim killed herself. That would be way coincidental if that's what happened. But I have nothing to show me otherwise. I have nothing to show me that it was a different day. I have nothing to show me that it was that day. But what I do have is what is in front of me, in that I fully believe you were aware that there is a 22, whether or not it was yours or it was hers or whoever it was, you knew it was there. It is a camper, and it was used for the protection of bears, or at least that is the excuse. But again, there are multiple other ways to protect yourself from bears. I've lived here again my whole entire life.
We've caught up. We've gone full circle here.
I've lived on more than 40 acres growing up my whole life. We have coyotes, we have wolves, we have bears, we have all kinds of other animals that threaten not only our pets and our livestock, but humans and our children.
It's the mooses.
There are other ways to protect yourself than a gun, especially if you know that you cannot use or possess or be in an area that has a firearm unless it is in a locked, contained facility or place. And I don't believe that was. I fully believe you knew that that was there.
All right.
And the underlying facts of this case are so extremely serious. They're so extremely serious.
We're gonna bail from this one. We've gone full
And
circle.
everybody, well, maybe not to the full extent, the defense believes that this is a prison case, but this is a prison case, and I don't believe that you can get the help in the community. I think you would be able to get more help.
All right, we're gonna bail on that one. It's heavy. Wow, that's heavy. We went full circle. We watched the ending first and then watched the beginning and had no idea it was going to go exactly where it did. Let's see. We have, it's lunchtime right now. We can take a quick lunch. Let me see if there's anything else we need to watch before we break for lunch. I think we're good. I think we're all caught up. All caught up on the important stuff. Judge Middleton's doing more landlord-tenant matters. Judge Simpson's done. He's in lunch. We're all good. We're all good. We're done. We've got everything. All right. Sentence was set at the very start. Yeah, he was given 3 years jail, 3 years in prison, and 5 years probation. Was how that one ended. All right, let's go to lunch, and then we'll see what we need to do coming back. It's obviously the court we're following today is on break because they have computer issues. And they've argued a couple things before the judge outside the presence of the jury. The jury was sent home first thing this morning before we even started. And there are a bunch of new KR docs, new experts on the case, possibly dog bite expert. Portal. Where are we going to portal to? How about we portal to a live baby goat watch with Valhalla Awaits? So you can watch some baby goats over lunch. How about that? Is that good? All right. We'll go watch some baby goats as a little palate cleanser from that one. Tonight when you go home, please tell the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live after lunch. After lunch. I have a bike to build too. I'm not going to use this. I'm going to use other tools. Got the tires and need to fix the tires. All right, we're going to portal over to Valhalla Awaits and check out the baby goats. Tomorrow, floating head? No, it's just for today. It's my leprechaun outfit. Goats do actually scream. Yes, they do. Are you coming back? I think so, Josh. I think so. Stay right here for a portal to Valhalla Awaits. Baby Goats live stream. We'll see you in a little bit. All right, have a good lunch. We'll see you guys. Bye-bye.
Because he's the guy.